ladies and gentlemen. As we gather here today to celebrate the 10th anniversary of the Association Arbitri, let us first express our solidarity with those affected by the recent floods in Bosnia and Herzegovina. Our thoughts are with the communities of Jablanica, Tarčin, Fojnica, Visoko, Kiseljak, and other affected areas. A humanitarian number will be displayed for those who wish to contribute to relief efforts. It is both a privilege and an honor to officially welcome you to the 10th Sarajevo Arbitration Day. The milestone reflects the enduring significance of arbitration in today's complex legal and commercial landscape. In just 10 years, we have welcomed over 50 domestic and international speakers, hosted more than 2,000 attendees, built over 15 partnerships, and established a vital networking platform for young professionals. I extend my deepest gratitude to our speakers and sponsors, City of Sarajevo, Baker & McKenzie, BDK Advokati, CLDP, Enova, Knocel, PwC, Mihaj Ilić Milanović Law Firm, Wilmer Hale, Schronher, Nikčević i Kapor, Kvericius, and Arbitral Woman. Your support has been instrumental in our common success. Thank you. Regrettably, our long-term friend and advisory board member, Mirèze PHILIPPE, is unable to join us today due to unforeseen circumstances. However, she has recorded a special message for us, which will be here now. Thank you once again, and enjoy the conference.
I'm honored to have been invited to address a few remarks. I'm disappointed, nevertheless, not to be able to share these moments with you in person due to a conflict event. Superlatives have been trendy in the past 2 decades in the media, in the showbiz and other public forums, to define just about anything and everything. One often hears or reads that a given event was the most spectacular performance, a level never reached before, the most beautiful song, an unforgettable show, you name it. Superlatives used randomly are hollow. The reason for which I make this remark is to say that none of the words I will use to express my admiration of arbitry lack real significance and value. I met Novina Jivremovic over a decade ago when we both taught an arbitration class at Pace University in New York. She informed me later that she was founding an arbitration group in Sarajevo, and that one of the objectives was to organize arbitration events. She invited me to be a member of the advisory board. I thought that her initiative was difficult because of the competition and that it was a courageous move. So I decided to support her and encourage her. Very shortly thereafter, I discovered a group of hardworking and talented young lawyers. I was amazed to see the quality of their work and how fast they became visible in the international dispute resolution community. Kudos to Nevena, Fahira, Armela, and the entire arbitry team. You were visionaries when you founded arbitry and successful in bringing it forward. The Sarajevo Arbitration Day contributed to put Sarajevo even more under the spotlight and to promote it as a potential arbitration forum. Arbitry has succeeded during the decade it is celebrating to be recognized by the international dispute resolution community. It is the quality of your work and the continuity of your initiatives that generated the recognition you have gained from your peers. Talent and perseverance pay. Founding and bringing forward arbitry was not a comfortable ride along a quiet river. The organization faced competition, challenges, obstacles, criticism. Arbitry team has overcome the difficulties and proven to be trustworthy professionals. The quality of arbitry's performance, the events organized, the mentorship program have kept it surfing over the waves daringly. Arbitry and its team has in a short period of time joined the platform of rising stars. The 10th anniversary certainly celebrates this progress. Onwards and upwards, I wish you many other successful years and raise my glass to your achievements. Thank you.
Good morning, dear friends and colleagues. It is wonderful to see you in this festive setting, in this beautiful City Hall where we celebrate now the progress of arbitration in Bosnia and Herzegovina. And all of you who have been with us over the years, I would like to profoundly thank you. We have also made some new friends since yesterday, and I'm now honored to introduce to you our dear friend, a brilliant authority on international arbitration, investment arbitration, and many, many more things, and somebody who you will definitely want to know more from after today, if you don't know by now. I'm speaking about, of course, Professor George Bermann, who has come to us from New York, from Columbia Law School. He's a renowned authority and a professor there already, a longtime arbitrator who has arbitrated in cases in diverse sectors, and has become the leading voice in all the areas that I have just cited. I will say a few words about him, by no means sufficient. I encourage you to find out more both in person and by research. But Professor George Bermann is the director of the Center of International Commercial and Investment Arbitration at Columbia Law School. He is also an active international arbitrator in commercial and investment arbitration, which is difficult in this world today, and he serves regularly as an expert witness before international arbitral tribunals, as well as before courts in arbitration-related cases. He founded both the Columbia Journal of European Law and European Legal Studies Center, where he serves as the director. In addition to teaching full-time at the law school, he is an affiliated faculty member of the School of Law Sciences Po in Paris, and the MIDS Master's Program in International Dispute Settlement in Geneva, where we are happy to report we have a recent new student from Bosnia there, who I hope she will have an opportunity to meet you there as well, and that she will benefit from your input. So without further ado, I have already taken up too much time from dear guest and keynote speaker. I will now gladly leave the floor to Professor George Bermann.
Thank you, Fahira. It's a real pleasure to be here. I'm sorry it's my first time. I wish I had had the pleasure of being in Sarajevo previously, and I look forward to my days here. Thank you, Fahira, for those undeserved remarks. I appreciate them greatly, and I want to congratulate you on all the accomplishments you have achieved in the world of international commercial arbitration for Bosnia and more generally. It's a real pleasure. Now, I have some remarks. I wouldn't exactly call them inspirational because I tend to be a more practical kind of individual. So I want to talk to you about something that has interested me greatly over the years and about which I have recently published a book that presents my ideas more systematically than I will be able to do so today. But for this audience, which I assume either deeply involved in the practice of arbitration or hopes to be deeply involved in the practice of international arbitration, I thought what I have to say might be of interest. So let me get to it immediately. In the years in which I have been, I would say, I have to confess, something like 40 years in which I have been active in the world of international arbitration, chiefly as arbitrator, I have been struck by the degree to which we tribunals, certainly when we come to deliberate, we encounter issues, far more issues than I would have ever imagined, as to which we have very little guidance. And I will try to make that concrete. I also was reminded of this by the frequency with which I'm asked as an expert witness to advise tribunals and courts about matters that you would think need no advice. So both in the trenches, so to speak, as an arbitrator, and before courts and tribunals as expert, I have found countless issues in which I and my co-arbitrators have felt very adrift, very without moorings, on matters of very central importance and highly recurring. Now, I call these issues, for reasons I will explain shortly, I call them twilight issues, not because I like that time of day very much, but for reasons I'll explain. I view them as twilight issues. Now, what am I talking about? I'm talking about recurring issues in the reality of international arbitration, as to which neither the parties' arbitration agreement nor the law of arbitration of the seat, nor the rules of procedure that the parties may have incorporated by reference in their arbitration agreement offer any guidance. And I want to repeat, this comes from personal experience as an arbitrator, and I detect it in my co-arbitrators as well, and come up in practice in which I approach them as an expert. Now, what are these twilight issues? Again, by definition, and I'll become concrete, but by definition, they are issues as to which neither the arbitration agreement nor the lex arbitri nor the arbitration rules give us any serious guidance. And tribunals struggle if they take the trouble to struggle. Sometimes they don't take the trouble to struggle, they simply decide without great thought. Now, I'm going to illustrate this by taking us through the life cycle of an arbitration and tell you that as it proceeds, these issues come up with regularity. You have all encountered all of these. They are not monumental, but they are central. So let me start with issues that come up when an arbitration is just getting off the ground, just beginning, at the threshold of arbitration. We all know what these issues are, but please put yourself in the shoes, if you aren't, of an arbitrator faced with these questions. And I'll anticipate them by saying, if these questions arose in a court, in a national court, we would have answers. For better or for worse, we would have answers, if not in the Civil Procedure Code, then in procedural case law in any jurisdiction. So let's start with the obvious question of whether and to what extent a non-signatory is bound by an arbitration agreement. Now, we're accustomed to that question coming up in a court, and we think we know how courts might approach it, but how should an arbitrator before whom a non-signatory is brought, how should an arbitrator determine the amenability of that non-signatory to claimant or respondent status in the arbitration? This is a threshold issue. Has a party waived its right to arbitrate? It's occasionally raised. If we were in a court and a party was resisting arbitration on the grounds of waiver, I can assure you that a court would have a means of making that determination. Has the claimant satisfied all the preconditions to arbitration? Let me pause by saying these are not novel issues, correct? These are issues the question isn't that these are novel. The question is, how do we deal with them? Preconditions to arbitration, we know what those are. Even the question of arbitrability. Now, an arbitrability issue or non-arbitrability issue comes before a court will deal with it, probably by reference to its own law on arbitrability. But what is the arbitrability law of an arbitral tribunal? I repeat, what is the arbitrability law of an arbitral tribunal? Those are just illustrative issues that arise before an arbitration is even underway. That's to give you some pause. Now we're in the arbitral proceeding, and there are a host of issues that we all encounter, as to which tribunals do their best, which I'm not sure is good enough. Well, we know interim relief. I think we have some bearings when it comes to interim relief. But let's talk about anti-suit injunctions. That's a relatively new but certainly growing phenomenon. Tribunals are being asked to issue anti-suit injunctions. Courts know how they feel about anti-suit injunctions. English courts love them. Civil law courts don't tend to love them. They have their attitudes, they have their approaches. What is the attitude or approach that an arbitral tribunal should adopt when it comes to the weapon of an anti-suit injunction? Here's one we all know. What are the rules of privilege? I can assure you a court would know. Does a tribunal know what the rules of privilege are? Does the tribunal and here's one where I was an expert recently, does the tribunal know what the proper rules are to apply on the fundamental question of res judicata? Can you believe a tribunal of arbitrators saw fit to hear from an expert? A tribunal of expert arbitrators wants to know from someone else what is the governing law on claim preclusion or res judicata. We all know sanctioning counsel. How about drawing adverse inferences? How do we go about doing that? Drawing adverse inferences. Even the use of tribunal secretaries. That's a hot issue I won't get into. Even merits issues. And my favorite one is one that I've only encountered once, but at least theoretically you all may encounter. When, if ever, may or should a tribunal apply the law of a jurisdiction the parties didn't choose on the ground that it is mandatory? Now that's a question that I can certainly speak for the United States. It's a question on which the restatement gives us an answer. We have an answer to that question. I can assure you that no matter how much ink has been spilled, on the question of applying the mandatory law of a jurisdiction whose law the parties didn't choose, we don't know what is to be done on that question. And I have to honestly say, because I experienced it all the time, rates of interest. Tribunals just wing it, if I can use that term. And this is serious if you care about predictability. And it's also not for the arbitrators. I should have said this earlier. Anything that is important to an arbitral tribunal is necessarily of importance to counsel. Because counsel needs to anticipate how an arbitrator is going to approach the questions I've just mentioned and so many others. So let's get to the heart of it. What actually should we do faced with these broad-ranging, wide-ranging, and perennial issues where we are a little bit at sea? Now, the reason I call these twilight issues is in part because they straddle issues of substance and procedure. But frankly, the real reason is because we're somewhat in the dark. And I'm being quite literal now. We're in the twilight zone. Not to be hyperbolic here. Well, I am being hyperbolic, aren't I? But we're in a little bit of a twilight zone with these kinds of questions. Now, what are tribunals doing, and what should they be doing about this? And this is something I've now studied generically. I've tried to study this generically. I was a little surprised why it hadn't really ever been done, to my knowledge. Had not ever really been done. Well, based on my experience, both as an arbitrator, as an expert, and an observer, One of the recourses that tribunals have is one or other body of national law. Faute de mieux. Okay? Faute de mieux, a body of national law. And they have a choice. At a minimum, and this is, I think, all too frequent, but we can discuss this, they will apply the law that applies in the courts at the seat. So they will apply the law of privilege, absurd as that may seem. They will apply the law of privilege that the courts at the seat apply. At one time, they even applied the conflict of law principles that were applied by courts at the seat. Now, we don't have time now to go into the advantages and disadvantages, I go into that a bit in the written product, of relying on the law of the seat. And when I say the law of the seat, please understand that I do not mean the law of arbitration of the seat. The tribunal is obviously governed by the law of arbitration of the seat. I'm not talking about the lex arbitri, I'm talking about what might be more accurately called the lex loci arbitri, the law of the place of arbitration rather than the law of arbitration. Well, in some ways it's very attractive as an option because we usually know the seat. Usually we know the seat, and usually we know the seat early. And so once we know the seat, we know which body of law to look at, and then we're no differently situated than we would otherwise be. We just find it out. So there's an advantage to applying the law of the seat, and many, many tribunals and experts will take refuge in the law of the seat on questions like this. We have a lot more to say on this subject. Let me just sum it up by saying I don't think parties chose their seat in anticipation of copying what courts at the seat do. This is sheer convenience, and it's not a manifestation of principle in the least, but it is commonly occurring. In my most recent instance with res judicata, my opposing expert was convinced that a tribunal has no alternative to applying the law of res judicata as recognized in the courts at the seat. The other alternative, another alternative, is obviously the lex causae, the law applicable to the merits. But honestly, most of these are not merits issues. Now we can, as a matter of, once again, convenience, transpose our choice of law clause, make use of it not only to choose our applicable law, but to choose our answers to twilight issues. And maybe there are some where it makes some sense. And one of the purposes of this book was to try to, for lack of a better term, to try to match twilight issues with sources. So one could plausibly say that the statute of limitations, a twilight issue, that the statute of limitations on a claim should be governed by the law applicable to the claim. That's a common view in civil law systems. No matter how often Americans try to convince you it's a procedural issue, the statute of limitations. So maybe that should be governed by the law applicable to the merits. Arguably, maybe even interest should be, but it isn't. But arguably, it could be because it's an element of full compensation, interest, and we measure compensation in principle by the law applicable to the dispute. So what I'm already trying to convince you of, I hope I have, is that these are a mixed bag of issues. There's no better term. They're a mixed bag of issues, and we really have to look at this. If we care to invest in this question, I want to tell you I'm unusual investing anything into this question. If we want to invest something into this question, then we're going to have to take twilight issues one by one. Now, a third possibility, which makes sense in some cases, is the law of the place of probable enforcement of the award if we can know at the time the arbitration is being conducted what is the place of probable enforcement of an award. And then, of course, lastly, but not very realistically, a tribunal could actually try to apply some conflicts of law rule of its own devise and come up with the law to govern a twilight issue. And I don't have the time now, but I have attempted to try to give some indication of what are the twilight issues where applying the law of the seat, applying the lex causae, applying the law of the place of probable enforcement makes some sense. And the case for some is stronger than the case for others. Now, I must stop here and say, I realize that this can only interest you if you're really interested in how arbitrators conduct or should conduct themselves on issues of this kind. I tend to take these issues seriously, maybe because I'm also an academic. So I kind of look at this from a different point of view. But just to give you an example, not to be comprehensive, we haven't the time. But if we think one of these twilight issues is an issue, the result of which may determine the fate of an award, then maybe we should be rather concerned with the law of the seat and the law of the place of probable enforcement. Example, non-signatories. The indefensible application of an arbitration agreement to a non-signatory, we all know, can lead to the annulment of an award, and it can lead to the denial of enforcement of an award. So frankly, could the tribunal's determination of arbitrability be a question? Because both the UNCITRAL model law tells us that the court of place of annulment determines the arbitrability of a dispute according to its own law, and the law of the place of enforcement decides the arbitrability of a dispute according to its own law, for better or for worse. That's another subject. What law should govern arbitrability? I won't really go into that. We have twilight issues as to which we should understand that there is no normative solution. I've assumed that there is a normative solution to every example I've given you. But in some cases, there is none, and we should accept that. We should accept that there are some twilight issues where, for better or for worse, it comes down to good judgment and common sense. I need to give you an example, don't I? Example. From among my examples, I would say that determining whether a party was excused from complying with conditions precedent to arbitration, and whether their failure, I'm thinking of the BG group case in case anybody's looking for an example here, whether a party is excused for not having done so is not going to be decided by reference to a body of law. I promise you, it will not be decided by reference to a body of law. Nor do I think a tribunal's decision on whether circumstances justify drawing an adverse inference against a party is going to be governed by a body of law. So you always need to be realistic. You need to recognize that maybe there is no normative solution to some of these, and we just have to assume the parties chose wise arbitrators. At least they are supposed to have done so. Or arbitrators who exercise good judgment. And the same good judgment they're going to apply to the merits of the case, they can apply to whether an adverse inference should be drawn on account of the failure to produce a certain document, or whether a refusal or failure to litigate in the Argentine courts for 18 months, as the UK-Argentina bit required, is something to be determined as a matter of good sense. In fact, it usually is, because we usually consider whether going to the Argentine courts for 18 months was a futile exercise. And futility, that's a matter of judgment. That's not a matter of law. It's a matter of judgment. So I want to be clear, I'm making a normative effort. I am, for the moment in this set of remarks, I'm assuming our only recourse is national law, and I'm recognizing that national law will not be responsive to a handful of our twilight issues, but it may be highly responsive to others. Now, we do have an alternative, and this is much less clear territory. And this is what it really has driven my interest in the subject. I happen to be a conflicts of law junkie, so as a conflicts of law junkie, I obviously like to think and talk about this stuff. But I also am thinking that we are in a field of law where we can make greater use, although there are difficulties, than we do of something that might be called international standards. And I invite you to think a little bit, I certainly have, about whether and to what extent we're seeing any evidence of transcending national law, and we're seeing any evidence of transcending good judgment, and imagining we see an international standard either having emerged or on the horizon, or embryonic, or however else you'd like to put it. And I do believe that in the long, long, long run, we're going to see more of this. And I think it would be salutary. There are those who disagree. There are those who definitely disagree and think we should not go into that realm of divining international standards. But I think we will. And we're already seeing it. So part of my inquiry, and it's simply provisional, unlike most of what I had to say, was what is the methodology? Is there a methodology for purposes of ascertaining whether there is an international standard, what its content is, and to what extent we should facilitate it when it doesn't yet exist? These are serious questions. These really are serious questions. And I think we're going to struggle with them. We're going to have to tackle them in many circumstances. And I don't have clear answers to these questions, but I've at least tried to start an effort to map out how we would go about determining and where we would look in order to determine whether we either have an international standard at our disposition or whether we should make whatever efforts we can to develop international standards. Now, I'm going to go through this very quickly because you have a long program today and you didn't come here to hear me. But we do have material, and I just want to share my ideas of that material. And I want to say before I even go into this that once again, some of these sources that I'm about to tell you about, or remind you of, frankly, not tell you, remind you of, will make more sense for some twilight issues than other twilight issues. So rapidly, we as a community have done a very good job, actually, of attempting to create and ascertain international standards. That really is one of the reasons why we are awash in soft law in our discipline. There may be no legal field where soft law plays as instrumental a role as it is playing in international arbitration. And what is soft law, after all? Well, I think it's a tool, it's an instrument, it's a device for coming up with an international standard. And it is a very fertile source. So what I mean to say is we're already on the road. Now, soft law is a contentious matter. The received wisdom today is that we have too much. I'm not one of those. I don't think we have too much. But there are those who will say, maybe there are many of you in the room, who would say soft law is antithetical to the flexibility that we're supposed to enjoy in international arbitration. And the question is, does soft law have to be antithetical to the flexibility that we have in international arbitration. I happen to think not, but soft law. Obviously, and this goes without saying, arbitral jurisprudence we need, and we are beginning to have opportunities and weapons, tools, I should say, for determining whether an international standard has emerged from a body of arbitral jurisprudence. Arbitral institutions, jus mundi, others are making their best efforts at digesting awards and enabling us to see if and to what extent the key, which is consensus, the key is obviously, I think, consensus, to what extent it is emerging in any of these areas. Thirdly, I think it's the case that international law, to some extent customary international law, but frankly more often general principles of law, I'm referring to Article 38 of the statute of the ICJ here, general principles of law is a promising source for us for some of our twilight issues. I would say, I haven't mentioned it yet, but I consider that corruption as a jurisdictional issue in investor-state arbitration, where it has become a jurisdictional issue, whether corruption has been shown in a given case is something where actually the surprising number of international conventions that we're seeing on corruption is not a treaty source for international standards. And then finally, I think we know this only too well, we are a community that writes about our field more than practitioners in other fields. We are certainly a community that gathers and listens to one another, to wit today. We are a community that gathers and listens to one another far more, I believe. I have children in law in other fields, so I have some evidence, okay? Far more than practitioners in other fields tend to gather and exchange ideas, and who knows, we may get a consensus. I've actually attended all too many events where we talk about the use of tribunal secretaries, and I think you know the answer here, I think maybe an international standard has emerged on what are the bounds of the proper practice of a tribunal secretary in the course of an arbitration. So, partly my project is looking back at what tribunals have had at their disposal and how useful they are depending on the issue at stake, and even more so I'm trying to look forward and seeing to whether there is a responsible way of positing that an international standard exists. Now, international standards, and I'll close on this, they do not exist or not exist. It's not binary that way. They don't either exist or not exist. They're works in progress. They are works in progress. So I think we should all be conscious, particularly those of us who are arbitrators, but frankly, those of us who are counsel and are trying to instruct the tribunal should be thinking along those lines of is a particular solution to a twilight issue, and there are many more than I mentioned, is there a particular issue or solution that is so compelling that even if an international standard has not yet emerged, we should promote it. And I think that's going to be necessary because international standards don't fall from the sky. So somebody has to make the effort for them to emerge. I need to be responsible myself. I need to say, what are the problems associated with creating an international standard? Now, of course, there are intellectual problems. There are empirical problems in ascertaining whether an international standard has arisen and whether it's one worth promoting. But I would just say this, and I'm now being, self-restrained, so to speak. A tribunal should be mindful of the fact that in trying to promote an international standard that hasn't yet the consensus behind it, but that the tribunal thinks deserves a consensus behind it, should think about the legitimate expectations of the parties going into that arbitration. Because those of us who may or may not want to contribute to the establishment of international standards, we have to recognize that it's not really just for our own intellectual stimulation, but there are users, and there are users who may be surprised and disappointed to find a solution to an issue of importance to them having been found in thin air, or where it looks to them as thin air. So even if you were to agree with me that this was a pursuit worth pursuing, then you might actually say, we need a code of conduct, dare I say, for those who are going to try to manufacture. We're going to need a code of conduct for those of us who are going to try to manufacture international standards. So with that, I close. I designedly address an issue like this to an audience of people I think either are or will be, to one degree or another, confronting what I've chosen to focus on, for better or for worse. So I thank you for your attention.
I hesitate to take this position right now after hearing all of this authoritative and well-designed remarks, just like Professor Bermann mentioned. These are things that will confront us all in theory and in practice, which we will be responsible for our own jurisdiction, for the region, and then, of course, internationally. And one more point I would just connect, and it's wonderfully all coming together, to your closing remark. Generally, the decisions we make because we think as practitioners or scholars are pro-arbitration, are favorable to arbitration, might not necessarily be so. Sustaining what we know and understand in our practice, and it's also a matter that Professor Bermann has tackled in his many, many writings and discussions before, what we think might be pro-arbitration does not necessarily have to be so. So while we are designing these international standards fit for our own future in the practice and study of arbitration, we have to be mindful that we need to keep it useful and beneficial for the system to sustain itself. And that will be up to us ultimately. Thank you so much, Professor Bermann. It's very obvious there's many, many decades behind this. Behind these words you have masterfully condensed into these keynote remarks. And now for all of us to gather ourselves, I will invite you for a 15-minute break, following which we'll hear for a talented and a brilliant panel on commercial arbitration, emerging issues, moderated by my colleague, Armela Ramić. Thank you very much.
Good day, everyone. It is a privilege to be here to moderate this panel on a topic that is really rapidly emerging and developing and reshaping the way we do legal work, and that is the use of AI tools in international commercial arbitration. Many of us in Bosnia and Herzegovina, legal practitioners, are just starting to use and explore the potential of AI in our everyday work. But internationally, the AI tools are very much in use. And for everything, really, from legal research and review of documents to their use in various stages of dispute resolution mechanism, including arbitration. Before we dive into the discussion, I would like us to take a step back and remember the time when we introduced computers and internet in our daily work. For us who are old enough to remember. Actually, there was a time when the court clerks were typing on typewriters. So when we introduced computers at the time, it also felt a bit unfamiliar and maybe unnecessary. And nowadays, we cannot even imagine the work without this technology. I think AI is at the same junction now. I think it's not going to replace legal professionals, for sure. It's going to enhance our work. It's going to provide us with tools and capabilities to do it more efficiently, to streamline our work, to make the decisions that are based on data and data-driven. However, as highlighted in the arbitration annual survey report, which I read for 2023, very interesting piece of read, the respondents who are arbitration experts, legal and non-legal, have actually raised serious concerns about the challenges of use of AI tools in arbitration, with some 88% respondents actually saying that they do worry about the risks, such as AI hallucination, which is production of fictitious information and data from AI tools, and also about the breach of confidentiality of their clients. There's also a growing concern about disclosure and transparency, with majority of these respondents, so arbitration experts, saying that almost everything should be disclosed by parties in the arbitration, from using of AI tools in legal research and reviewing of documents, and also majority of them thinking and believing that AI should not be used in expert reports and not in production of arbitral awards. So these are interesting points to discuss for today, and I'm definitely looking forward to our panel today, consisting of international experts who are lawyers and non-lawyers, who are at the forefront really of these developments. I look forward to their insight and input that will give us some guidance as to how we can explore AI in our everyday work, but also at all times staying true to the fundamental principles of our profession, which is fairness and justice and transparency. So let's get started. I'm not going to introduce my panel members because you see all the biographies behind. I'll start with Marleen Krueger, partner in Wilmer Hale, and we are lawyers, most of us here, so we love good old regulation. So we'll start with regulation. How do we regulate the AI? Do we regulate the AI? And how it is actually possible to regulate it when it's a topic that is so developing basically on day-by-day basis. So how do we do it internationally? Obviously, I'm not talking about Bosnia-Herzegovina. I'm talking about the European Union and international regulations. So please, Marleen.
Thank you very much, Dina. First of all, it's a pleasure to be here with all of you today in beautiful Sarajevo. I'm really very happy to be here. As Dina said, I'm going to start by addressing how to regulate risks associated with the use of AI in international arbitration. In the full knowledge, as Dina said, that this is a very fast-changing area of technology and of law. So what we think about regulations today might be outdated tomorrow, but I'm going to try to give you at least a snapshot of the current status. Now, we're all aware of the substantial risks associated with the use of AI, and Dina mentioned a few of them in her introduction. The occurrence of hallucination, the potential breach of confidentiality, the loss of trust by the parties in the trust that a human being will arbitrate their dispute, and all of these are very serious concerns. And so various approaches have been taken as to attempt to regulate those risks. First of all, there's some statutory regulation, the most prominent of which at the moment is the EU AI Act. There have been other regulatory attempts worldwide as well. For example, in late September 2021, the Brazil's Congress passed a bill that creates a legal framework for AI, but I'll focus on the EU AI Act for now. As many of you may know, the EU AI Act came into force earlier this year on the 1st of August 2024, and it is commonly held to be the first comprehensive regulation on AI by a major regulator anywhere in the world. And the Act is very proud of that, but it takes a risk-based approach, which means that it classifies economic activities according to the likelihood of harm caused by AI systems, and the regulatory duties vary according to the level of risks in which the relevant activity falls. And in this context, it's worth noting that the AI Act actually does not refer explicitly anywhere to arbitration, but it does refer to, and I quote, AI systems intended to be used by a judicial authority or on their behalf to assist the judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts, or used in a similar way in alternative dispute resolution. And the most common view is that this reference to alternative dispute resolution is also meant to cover international arbitration. And in this context, the Act distinguishes between different regulated entities. So the most stringent duties fall on providers, importers, and manufacturers of AI systems, and none of that in a usual circumstance will apply to the users of international arbitration. However, so-called deployers of AI systems also fall under the scope of the Act, and a deployer is defined as, and I quote again, any natural or legal person, public authority, agency, or other body using an AI system under its authority, except where the AI system is used in the course of a personal, non-professional activities. So if you apply that definition, then arbitrators, to the extent they rely on AI systems as well as counsel, will fall, to the extent they use these AI systems in an arbitration, in a professional activity, fall under the personal scope of the Act. And once you've crossed that threshold, the Act then applies. Then the next question is, what's the local application? So it is the EU AI Act, so it has a certain limited application. However, the definition is somewhat vague in the context of international arbitration. So the Act applies, it says, if the deployer of AI systems either has its place of establishment or is located within the EU, or has its place of establishment outside the EU, but, quote, where the output produced by the AI system is used in the Union. So again, that is just complicated in, or establishing whether or not the Act applies is complicated in the context of international arbitration. So, for example, if you have an arbitration that is seated in Sarajevo, but one of the arbitrators works remotely from somewhere in, say, Germany, does that mean that the AI Act applies? Arguably, yes, it does. And what if one of the parties, so none of the arbitrators are seated anywhere within the EU, but one of the parties is a EU company? Does that mean that if the arbitrator uses an AI system in the creation of the award that is used on a party located within the EU, and as such where the output produced by the AI system is used in the Union, that would also mean that the AI Act applies to those arbitrations as well. So just because it's called the EU AI Act, it actually has, or at least the potential is there for quite a substantive use in international arbitration. So that's the regulatory side. There's also some soft law regulation, and we heard from Professor Bermann this morning that there's some view that there might be too much soft law regulation worldwide, and maybe people will say this is another area of that, but here we are. And the most notable example of current soft law regulations for AI are the Silicon Valley guidelines on the use of artificial intelligence in arbitration. And for those of you who attended the last Sarajevo Arbitration Day, I understand that there was already a presentation on the Silicon Valley guidelines last year, but at that point the guidelines were only in draft form, and they have now been formally published at the end of April this year. And they say they are intended to serve as a point of reference for arbitral institutions, arbitrators, parties, and their representatives, including counsel, experts, and where relevant, other participants in the arbitral process. And they also say that to that end, the guidelines provide a model clause that can be incorporated into procedural orders to make the guidelines applicable to all participants involved in a particular arbitration proceeding. So they're very much intended to be referred to, similar to the IBA guidelines, in procedural orders by a tribunal to incorporate the guidelines into the proceedings in the arbitration. And maybe we can discuss what exactly the Silicon Valley guidelines provide during our discussion later. And lastly, of course, tribunals and parties could also come up with their own bespoke rulings and decisions on the use of AI in their particular arbitration. So they might decide not to incorporate the Silicon Valley guidelines, but basically come up with their own bespoke system of how to use AI or not to use AI. And I've personally seen cases, at least in recent months, where tribunals at least suggest discussing at the initial CMC at the outset of the arbitration whether AI systems should be used during the arbitration, and if so, to what extent and under what conditions. And those agreements reached based on the discussion at the CMC, or if the parties can't agree, then the tribunal's decision in that regard will then very often be reflected in the tribunal's first procedural order. And interestingly, I did a similar panel on the use of AI at the DIS Spring Conference this year, and there we took a poll of the audience, at that point a few hundred people, direct users of arbitration, on whether what sort of approach they want to take, or they think it would be beneficial to take in regulating the use of AI. And the results were interesting. So 36% held that the use of AI should be regulated by soft law. Actually, that was the majority. 34% were in favor of the use of AI to be regulated by a tribunal, so in individual agreements with the parties, between the parties and the tribunals. And only 19% said that no regulation would be required at all, and 9% called upon legislators to intervene. So, I mean, of course, it will be interesting to see if those opinions change over time as more of these regulations come into force and are being used in arbitration. But I thought it was extremely interesting that at least that poll suggested that direct users of arbitration still want to maintain some flexibility in exactly how to use AI systems, but also recognize that there absolutely needs to be some regulation associated with the risks.
Thank you, Marleen. It's very important what you said. Majority of us, the practitioners, actually do want some kind of regulation, whether it's soft law or hard law or whatever. So there's definitely a need to do it, and I think that comes from our position that we're still unsure how to use it. And I'm wondering about disclosure obligation. We talked about it, I talked about it briefly. There's obviously growing concern about disclosure of the use of AI, and there are certain ethical issues connected with that. Is there anything in the regulation that you just mentioned, AI Act or Silicon Valley rules, doesn't matter, that actually concretely addresses this issue, and what would be your position?
Yeah, so there is. The most specific is actually in the Silicon Valley guidelines, and interestingly, they say, or they suggest that the most appropriate approach should be that disclosures that AI tools were used in connection with an arbitration is not necessary as a general matter. So they take the position that as a default rule, you don't need disclosure, and that decisions regarding disclosure of the use of the AI tools shall be made on a case-by-case basis, taking account of the relevant circumstances, including due process and any applicable privilege. So I thought it was extremely interesting that they took the approach that as a general matter, you don't need to disclose the use of AI, which I don't think is probably the natural approach lots of us in this room would take, because, I mean, as we said, it's a big step to use AI tools, and there are certain concerns, very serious concerns associated with that. And how will you ever be able to address those concerns if you don't even know that AI systems are used in your arbitration? So I think that will be interesting to see whether that general default position changes as more of us see the use of AI in arbitrations. Interestingly also, they say that where appropriate, the following details may help reproduce and evaluate the output of an AI tool. So if there is a disclosure, or if it's appropriate to disclose the use of an AI tool, they say you should disclose the name, version, and relevant settings of the tool used, a short description of how the tool was used, and the complete prompt, including any template, additional context, and conversation thread, and associated output. So I think that actually, interestingly, that then goes into a lot of detail as to what the specific disclosure obligation then would be. And I think it's not enough to just say, yeah, I used an AI tool, because that just, actually that opens more questions than it answers, right? Like, what sort of AI tool did you use? How did you use it? In what context? And what are the prompts? Like, what questions did you ask the AI tool? And how did you ensure that it gives you an accurate output? So I thought that's helpful to have that guideline in terms of what the specific disclosure obligations should be. However, I expect that, I think the general consensus will be that in more cases than not, such disclosures will be required.
Mm-hmm. But that's on case-by-case basis.
That's on a case-by-case basis, yes.
Yeah. Thank you, Marleen. We'll come back, obviously, with the questions. I would like to turn to Aida Spahović, our dear colleague from Baker McKenzie. And I asked Aida actually to give us a very practical presentation on how they use it, because my belief, and this is just my assessment, is that legal practitioners in Bosnia and Herzegovina don't really use a lot AI tools. We are just sort of starting to explore the potential, and I think that undeniably we are going to use it more in the future. It's coming. There's no stopping it. So I asked Aida to give us a short presentation of how they actually do it in their law firm and how she uses the AI. So I turn over the floor to you for a practical issue of the things. Thank you.
So thank you, Dina. I'm very happy to be here, especially in view of your 10th anniversary. I will make a few remarks on the practical issues that arise when it comes to the use of AI in international arbitration. But before we come to that, I would like to take a step back and ensure that everyone has a basic idea of what it is that we're talking about. So I will play a very short screen recording of an interaction with an AI tool. The particular tool is Microsoft Copilot. It is not the most sophisticated tool. It functions on the same way as ChatGPT. But I believe it is a good example for those who still did not have an opportunity to see how it looks like. So I asked the tool to summarize our topic of today, and then I asked it to create a presentation on it. So we can play the video now to see how it looks like first. Yeah. So the most obvious advantage of the use of such tools is potentially increased efficiency, because theoretically we could use these tools to outsource our organizational and administrative tasks, such as document review or legal research or drafting of various summaries of documents and submissions. But there are practical issues that arise in this context which hinder this potential to be realized. The first issue is the accuracy of the content that is generated by AI. Or more particularly, the lack thereof. I'm sure a lot of you are familiar with the quite an extreme example of inaccuracy of AI-generated content, where this individual in the United States tried to pass the bar exam using AI and then quoted non-existent case law. So this is a rather extreme example, but although the AI tools were developed ever since then, it remains that the accuracy is not to be assumed. This means that whatever is generated by an AI tool has to be reviewed by a lawyer before it is used for any purpose. And I believe that is the policy of any firm that has an AI tool or uses an AI tool. There is a way to increase the chances of getting a more accurate content. And this is the so-called prompting that Marleen also shortly mentioned. This means basically that instead of just asking the tool to conduct a certain task, you provide context as to why you need this particular thing. So I'll give you an example for a legal research. Instead of just saying, can you find the most recent case law on this matter, you write, I'm a lawyer practicing in Bosnia and Herzegovina. I advise a client on a matter. Can you provide the most recent case law on this matter and cite sources? So in that case, the chances that you receive a more tailored response are higher. But in any case, you have to review what you receive, and the accuracy is definitely not to be assumed. So of course, that impacts this idea of efficiency to a great extent. The second consideration that is probably even more relevant for international arbitration is confidentiality. The AI tools work in such a way that they learn from your input. So whatever you provide remains, and then they use this input to their further output creation. This means that if you want an AI tool to summarize a document that is confidential, or to summarize any information that is confidential, or use confidential information, you would have to provide this confidential information to the tool. And in doing so, you would compromise confidentiality. So this significantly narrows down the use of AI tools in international arbitration, at least when it comes to tools that are available online, such as the one I showed. There are tools that maintain confidentiality. These tools are usually created for a particular purpose, such as document review or legal research, but these tools are usually not available online, and they are created for a particular firm and similar. In any case, confidentiality in this context is also not to be assumed, and when in doubt, don't use confidential information for these purposes. So I will conclude now for the sake of time. Thank you.
Thank you, Aida. You mentioned something that I was also trying to get my head around the last few days about confidentiality and using confidential and client documents actually in these tools. What you showed us is a co-pilot. I've learned from Aida that it's just a tool based on ChatGPT, sorry. It's just sort of a more advanced version adapted to legal firms. But it's the same set of questions. Like when we use ChatGPT, it's also always for me a question whether I can or I shouldn't use the client's document in these tools, because these tools are connected to internet, obviously. The response I got from IT experts is that no, they don't guarantee confidentiality for sure. So the only way to get around it is to have a custom-made tool for you that will not be directly on internet, but it will be for the law firm or whatever. But if this is not too improper to ask. Have you, come from a really international and huge law firm, have you put into place any internal regulation about how to use this? Is that a way forward? Is that something we should do to maintain confidentiality, at least to show that we've been prudent in using AI tools?
So, yes, generally the tools do not guarantee confidentiality. They have to be technologically restricted.
Right.
So in a certain way, they have to be tailor-made. At our firm, we do have a set of AI tools. But for instance, for Copilot, we are not allowed to use confidential or client information,
Right.
even though it is restricted. And I think it is at least my impression that there's still a great reluctancy to use any sort of confidential information, except for tools that are specialized for particular tasks. There are tools that only that serve for document review, for instance, and then in this context, they're only powered by AI. And you have to upload documents that are confidential to this tool so you're able to review them. So for such cases, we do use confidential information.
And I'm assuming they do guarantee some level of confidentiality.
Yes, they definitely guarantee confidentiality. Yeah.
Thank you, Aida. I'm sure we'll have questions for you in that regard because we've just started using it here. I will turn to Sirshar Qureshi, PwC. He's not a lawyer, so he's a quantum expert. And I will ask Sirshar to give us his insight on how he uses AI tools in his everyday work. I know from our discussion that he's rather positive about it, which is a good change as opposed to lawyers who are always risk-oriented. Sirshar has a different approach, so please.
Thank you, Dina, and first of all, thank you to the organizers for inviting me here today. A lot of hard work to make this event happen, and I'm pleasured to be here for this event, so thank you, and what an amazing setting as well for the venue. I was thinking to what Dina said at the start. She said, like when we started working, when I started working, there was no emails. And that sounds so weird that, well, how could you have had a life without emails? You had used dictaphones, to dictate to your secretary. I mean, these are all skills, I think, that are just long forgotten or done in a very different way. So yeah, that's quite how things change Yes, unlike my fellow panelists, I'm an accountant, and I'm a quantum expert. And as I work in PwC, as much as I am upbeat about the future, I would say my firm is also very considerate about all the points that have been discussed. So therefore, I have a lot of restrictions about what I can do and not do. But we are excited about in terms of where we're going and what needs to happen and what could happen. Maybe it's worth explaining to, and maybe not everyone's aware of what I do, just to put it into context about how AI affects my life. As a quantum expert, I am producing expert reports, if I'm on the claimant side, to justify a claim. And then there'll be another expert on the other side who'll be saying how wrong I am. And then I would write a report back to say how they were wrong, and then they would write back to say I was wrong. And then we end up sitting in front of a tribunal at a hearing, and we get cross-examined by some very smart people who try and make you look like idiots. And so therefore, I feel in this process of mine, there is a lot of principles in terms of 4I principles of another expert looking at your work. There's the cross-examiner looking at your work and challenging you. And then there's a tribunal. And for the tribunal, just so you understand the duties of an expert, the duty is towards the tribunal to be helpful, to be objective, to be independent, even though you're party appointed. So there's a credibility point here. So I say all this just to put into context where AI sits. I can't put anything in my report that I don't know where it's come from. I can't put in my report if I don't know, there has to be an exhibit to it, because the other expert needs to understand where I've arrived at my conclusions. So in a lot of respects, my hands are tied on a lot of this. So therefore, I feel that, and certainly my firm wouldn't allow me to be putting confidential information out into the ether. That's certainly not going to happen here. And we have our own tools internally. We're testing a lot of tools, but we're doing it very cautiously and very carefully. Where I would say AI is now, if, say, in the PwC world, if we have a partner at the top, then we have a director, senior manager, manager, senior associate, associate. I think AI is about the associate level, just so you understand. But with time and understanding how to use these tools properly, and I think the regulation is there for a very good reason, it will go up the chain. It will go up to senior associate manager. It's not there today, I wouldn't say, but certainly how we're using it in everyday practice is, if I was to look at what I do from start to finish, say analysis of documents, summarizing information, if I was to really break down, in some of those things they can be semi-automated with AI, some areas could be automated in AI, but the whole process needs to be controlled. So I'm afraid I'm not to the level of, here's an expert report for the other side, AI, off you go, write me an expert report. That's not happening. Not today, anyway. Not today. So it's very much, we're looking at the process. So just to give you some concrete examples, we had a case where we had thousands of documents in English, Cyrillic, and we had to extract certain information from them. Now, we trained the AI tool to pick up the information and analyze it. Now, the same job could be done by human beings, but it would just take you a long time. And here we were able to analyze it, the information. We could only analyze 80% of it because the other 20% wasn't readable to the human eye anyway, so therefore that's a bit unfair to say to AI to read something that we can't read. But obviously there you have to have checks and balances to check it's correct, to do quality checks around it, because you can be certain that the other expert will certainly step in and tell you where you've gone wrong, because that's their job, I suppose. So I feel that there's always some challenges there. The other part of it is when we're looking to sort of summarize facts in submissions, it's more just to summarize it as an easy summary. You know, okay, in the submission, okay, what are the salient points around the quantum? What are the key arguments? And it more focuses the mind, but it doesn't replace having to do the job. So I think it's just a helpful summary to get us started. And maybe just the third example I'll give you is just as an example of say, we've also had tasks, because I've always from the beginning, well, I've been with PwC, 27 years, and we've always had a forensic technology team to work with. So for me, I've always leaned on technology, and they have a lot of tools that they bring me. And so therefore, for me, it's, here's a problem, how can I have technology to help me? Whether it's e-discovery or data analytics or analyzing unstructured data. This is before the fancy thing about AI. This was all going on before. So now, I just feel this is another tool in my toolbox for me to use in the right times and the right moments. So it's not like I can use it across the board, but certainly to try and ensure that we use it properly in the right way. But so the example I was going to give you was in terms of, we were asked to review awards. So we had 1,000 awards in the competition area, and we were just asked to extract it in terms of the key information, and we trained the tool to do that. And we were able to do the same task that would take one lawyer 10 hours to review one award. And this could be done in seconds across the whole population. Now, obviously, you had to do the quality checks, we had to have lawyers review it. So we're supporting also lawyers in terms of how they're doing things and what they're doing as well, just providing technology, because obviously I have a team to support me, and it'd be a shame if it's not supporting the legal team we're working with. Maybe I'll stop there, Dina, just in case you've got questions.
Yeah, of course I do, many. The first one is about the problem. You're obviously very positive about AI, and you're looking at it as a tool, technological tool that we have. But it's not really Google search. It's a tool that you can train, that can extract data, that can actually give conclusions. My question to you. Have you had in your practice the instances of AI hallucination, for example, where I know you check it for sure, but have you ever encountered that the AI tool provided fictitious results?
Well, I know it happens. I mean,
Yeah.
I asked, obviously, because I'm playing with these things, because it's all about the prompts and what you ask.
Right.
But if you're in the OpenAI area, say if I was to ask, tell me about PwC Czech Republic, I put that search in and it came up with a lot of things in there, all pretty good, except the last sentence. The last sentence says, and is headquartered in New York. I know we're not headquartered in New York. That's not how our firm is set up. So clearly it's picked up a hallucination there. The fact is wrong, but to the average trained eye, you wouldn't see that mistake.
Right.
And that's just a practical example. So the way we use AI primarily at the moment is we have it off the grid. It's not connected to OpenAI. It's usually within a certain contained data source or documentation.
So it's your custom-made tool.
It's a custom-made tool. We can put all the documents within the hearing within that tool and then ask it questions. So there is less likelihood of hallucinations if it's not connected to OpenAI. OpenAI comes into play when you're asking it, say, okay, give me the information about the financial economic system, say, in Iraq, for example. And it'll give you something. But you need to double-check those facts. You need to know where the sources are coming from. Because certainly having just blind statements without knowing where it's coming from, I think, because you know, there's sources and there's sources. And you need to make sure you've got reliable, credible sources to act upon. So this is definitely an issue to be aware of. And I think then we manage it by keeping out of the grid. And only if you go in the grid, you know it can happen. And I think we would not use it that often.
Right. Actually, in this survey report that I mentioned, arbitration survey report from 2003, I think it's important because the respondents are arbitration experts, legal and non-legal. So you really get a sense of how the experts look at the AI. The first thing that struck me, there are not actually many of them who use them in their everyday work. It's much less than I expected, something like 20–30%. People who use AI in everyday work. But there is majority of them, when asked, they think that AI should not be used in two things, and that is production or drafting of arbitral awards and expert reports. So I don't really know what that means, because now listening to you, you obviously use AI tools in your expert reports, and I don't see any problem with that. How do you comment on that? And do you think it's just a matter of disclosure?
I think informing stakeholders, like disclosure of the parties, the arbitrage tribunal of areas where you may have used it, I think sounds sensible. But AI is not writing my expert report.
Right.
We are still writing our expert reports. What we're doing is doing the analysis, so providing efficiency to process. Arbitration's about cost efficiency as well, so you can do it in multiple ways. So here I think it's more that still the conclusions are mine, they have to be mine. Every word has to be, I have to sort of sign on blood on everything I write in the report. So for me it's very clear that the reports, that's why I said today, it's not writing expert reports.
Right.
And that's where we are today, you can do analysis. But I would say in the future, well, let's say, I think it's a potential that we could get there, but at the moment we have to do it step by step. And as you know, as we all had to go through our careers, we start at the bottom and we work our way up. And I think AI has to do the same thing.
Thank you, Sirshar. Yeah, timing is always an issue. I would like our audience to see whether there are any questions, and please feel free to ask them in Bosnian. We're not really exclusively English. Yes, please. If you, I don't know if you need a microphone, maybe not.
Hello, so Relja, I'm associate professor at the University of Warwick, and apart from fighting the losing battle with students about using AI, which is a topic for another day, I would pick up on the need for disclosure. So, the Silicon Valley rules, basically I think get from a good starting position, because as Sirshar just said, if you're the one who's ultimately signing off on something that AI wrote, okay, and you're misleading the tribunal or judge, right? It's on you. Yes. So if you need to check what the AI has produced, what AI has given you, and you're fine with it, and you submit that, it's up to you. No one's gonna, you cannot use I use AI as a defense, right? Because you won't use that defense for, I don't know, I'm associated with it, right? Or someone else or whoever wrote it. That's not the defense. So why is that not the good starting position? It's up to you to check and sign off on what the AI does now.
Yeah, it's a question of responsibility, actually, for what the tool is doing, which I agree absolutely about. And I think it goes into, Marleen, into how the regulation is now looking at this issue.
Yeah, I agree with you. I think that the starting point is good. I think the problem with this is, especially in the context of expert reports, that to a certain extent it is trust in someone's expertise, right? So yes, you have to take responsibility for the end product, but to a certain extent experts are experts because they can do things that other people in the room can't. And there will be issues when someone writes a quantum expert report that you just accept because it's their expertise, you trust them to give you to the best of their knowledge, the right answer to this. Now, your trust issues would probably be different if you knew that 90% of all these conclusions were done with the help of an AI tool. It might still be right, but you don't know that, right? So I think because we're humans, initially, or like that, studies have shown that it feels much easier for us to trust another human being, despite the fact that they're more often wrong about something than machines. But it's easier for us to trust a human being, and so it's easier for us to trust the expertise of someone and to say I'm appointing an expert in this case because there is a certain area of the case that someone needs to look at and then tell me out of their personal expertise what the best issue is. Now, if I know that an AI tool has done most of this and there's basically just a human being on the front and saying, yeah, this is what the AI tool has told me, I think people would find that much harder to trust. And I think it would be difficult, or it would be a different assessment by the tribunal to assess an expert report that has been provided by an AI tool than a human being. I think that's just how we operate. That might change over time, and where we're absolutely trust in AI tools. I don't think we're anywhere near that, and frankly, I don't think we'll ever get there. That people trust AI tools more than they trust human beings.
Can I just make a quick comment? I think the question I have is not, to answer your question, is not of today. My question is, say, in 15 years' time, 20 years' time, when that associate has gone to partner level AI, would you be in a position, would you have a situation where the arbitrator has a button to press to give you, okay, this is the loss of profits assessment, and this is the calculation of how it would happen? Because the interesting point there is, obviously, the arbitrator may have that in the future, but then you also need to understand everything behind it. And I think there'll be so many things potentially wrong with it. That's why I don't think the status quo will change, and you'll still need experts, you'll still need lawyers, and I think that won't change.
Exactly.
Yeah.
Hi, I'm Mirèze from Relja. Sorry. Thank you for having me here. It's really useful, really enlightening. So I just have an observation, or rather than a question. I think you rightly mentioned a couple of risks, including accuracy. Now we see the AI is generating some of the cases in US, particularly inventing, so to say, in addition to confidentiality issues. And I just think, I think that, to my knowledge, there are some predictions that within less than 6 years, by 2030, the AI will achieve Sentinel, i.e. the full level of human intelligence. So this is to back what you mentioned, Sirshar. But let's go back to things we mentioned, emails. Nowadays in courts, when we want to support cases, we provide Google Maps, we provide data. No one questions directions, no one questions the telephone numbers of certain companies. We just put them from Google, we assume. So we have achieved a level of trust, so to say. These are the risks that we will be facing with. I have never heard that there has been a questioning of computer forensics findings based on a software that has been used. Algorithm as such. Now, there are other issues when it comes to AI. Some believe that it's quite vogue, that it is leftist. Some are more leftist than the others. These are the issues that we are facing with. But as much as we are looking at these risks, I think that the companies who are interest-driven will try to address these issues. And it's good to talk about this topic, but it will be evolving as years are coming, and as Sirshar mentioned, is going up. So it will be useful to see in a couple of years now what level has been achieved and what is the level of accuracy and the trust to the AI. Nowadays, it's doing rudimentary, more or less, processes information, but it will achieve a level of intelligence. And just to add, as much as we're looking at Copilots and ChatGPT, which are more or less text inputs, now there are aspects of it, visual ones. There are also AIs which are being trained in human voice for health and other reasons, which may become parts of modules of human mind generation. So it will be looking at things which humans now can do and computers still cannot do. But I think it's just a matter of time that they will try to emulate a judicial mindset.
Thank you. Yeah, very shortly.
So
Armela is going to kill us.
Yeah, sorry. Just very shortly on that. I think that's right, but the reason why we trust Google Maps, for example, is because we think we can test whether or not it's true. If it shows me that there is a street there and there isn't there, like the street isn't there, I feel like that's easy enough so that I can test that proposition and that it just helps me. Now, expert quantum reports, if it was just crunching the numbers, I think we would be much more ready to accept AI tools. But, and I think that was your point earlier as well, it's just not. That's why we need quantum experts at the moment in very complex arbitrations. And I think that is where that issue of trust comes in. And the tools that you spoke about where they imitate a human voice, I think is intended to overcome exactly that gap where we're more likely to trust a human being and the AI tool just pretends to be a human being in order for us to get over those trust issues, which I think is sort of scary, but we'll see how we feel about that in 6 years.
Thank you so much. I would have to stop with the questions because there's another panel coming, but we'll have opportunity to discuss at lunch, so please feel free to talk to our experts. And Armela is actually waiting for another panel of the title, The Evolution of Construction Dispute Resolution Under FIDIC Contracts. I know you love FIDIC, so whoever does, please stay, and we'll just replace these.
Hello again, everybody. I know that we're a little bit late, but we can promise you a very interesting panel. Since I know there's a lot of attendees who loves FIDIC, half of you actually are from law offices, and another half is engineer. In accordance with that, today with me is Senka Mihaj, an attorney at law from Belgrade, an expert for FIDIC contracts, and we have Mr. Taner Shan, an engineer, also an expert for FIDIC contracts. So the FIDIC general conditions are currently the most commonly accepted international standards for contracting in construction and engineering works used in Bosnia and Herzegovina and in the region. Construction projects are typically very complex and time-consuming, as you all know, involving a number of parties and project participants. So it's not surprising that disputes are very frequent in this sector. A broad scope of knowledge and significant experience is required to adapt the complex general FIDIC conditions into our legal framework. Since we have started this discussion even last night, and we have a lot of open questions, so I ask you to feel free to ask questions, to join the discussion. It will be very welcomed. First of all, since we have very diverse audience, I would like to ask questions. What are the main characteristics of FIDIC contracts? In which type of projects are they usually incorporated?
Thank you very much, Armela. It is a great pleasure to be here amongst you, and I hope that you will enjoy our today's discussion. Regarding FIDIC contracts, as Armela said, they provide a standardized format which is widely accepted and recognized in the construction industry. This ensures clarity and consistency in contractual arrangements. FIDIC contracts aim to allocate risks fairly between the parties involved, the employers, the engineers, and the contractors, thereby clearly establishing of what is expected of each party involved in construction project. They also provide a framework for effective dispute resolution through adjudication, an amicable settlement, and arbitration. Overall, FIDIC, in my view, promotes transparency, fairness, and collaboration between the parties involved in the construction project, aimed at ensuring successful project delivery as well as minimizing conflicts. Regarding the applicability of FIDIC contracts can be widely applied to various engineering and construction projects, starting from traditional civil engineering projects such as buildings, highways, dams, to high-tech windmills, heavy-duty oil and gas process plants. Best known, I may just make a brief reference, best known of FIDIC contracts are FIDIC Red Book, where the engineering and building works are designed by the employer, and also FIDIC Yellow Book, where the engineering building, specifically mechanical and electrical plants, are designed by the contractor.
So in accordance which project is done, we choose which type of FIDIC book shall we incorporate it in the contract. Is that correct?
Depends on the procurement route which shall be chosen by the employer. If the employer gives the so-called design specifications, he specifies the scope of the works which must be done, and also how it should be done. So giving a little discretion to contractors in terms of the contract performance. And this is the procurement route where the Red Book would be suitable. Regarding the Yellow Book is quite the opposite. There is a so-called performance specification where the employers are interested in the outcome, in the results to be obtained. For example, how many megawatts the hydropower plant should produce. And how those results will be achieved is largely left to the contractors.
Okay. My next question is, what are the advantages and disadvantages of FIDIC? From my perspective as attorney at law, that is the main question that clients asked, actually. Why should I incorporate FIDIC? Having in mind, of course, that the investor didn't really request it. But what would be the reasons why should we incorporate FIDIC? I would ask this question also to Senka and to you, Taner, from your perspective as the engineer, and then I will ask this same question to Senka. What would you suggest to your clients? Why FIDIC actually?
Pre svega da kažem dobar dan svima i zadovoljstvo je biti u Sarajevu danas sa dragim kolegama, dragim ljudima, pogotovo po ovako lepom vremenu. Reko malo lokalnog jezika da čujemo danas.
Hvala.
Well, I would say that the first question that I would ask is myself.
Okay.
Should I consider FIDIC at all if I'm about to start some construction project? Should I consider FIDIC? And that is not always yes question. Sometimes it is no. So if I'm to get international financing, that the answer is not only yes, but probably you have to use FIDIC forms. If we are talking about major infrastructure projects, then again, the answer is yes.
I just had to ask you a quick question. Is there a financial amount of the contract?
That is
the value of the contract?
That is also, yeah, that is also my third point.
Mm-hmm.
So we do not have financial, international financing, but should I consider FIDIC forms if the value of the construction project is $500,000? Well, probably not, I would say. Probably not.
Okay.
Why? Because FIDIC projects are demanding. They are time-consuming, and that costs.
Then I again have to ask you a question. But then why should we incorporate FIDIC and use FIDIC in construction?
So if we have big infrastructure projects,
okay,
if the projects are of a great value, of course that there are some advantages of FIDIC.
Which are?
Which are, first of all, FIDIC is probably the form of the construction contracts that regulate the rights and obligation of the parties in most detailed manner. And that is an advantage in a big project. And it also has, as Taner mentioned, some subjects, let's call them subjects, included in the project, which is very helpful to have. And that is engineer and dispute adjudication board. And that is very helpful to have in a big project, which usually lasts for years. And usually during those years, we will have some questions or disputes, to say, between contractors and the employer. And it is useful to resolve these disputes during the project and not to wait the project to end. And this is also the mechanism that the FIDIC provides.
Okay. So I would like to ask the audience, what would be the reasons to use FIDIC in the region? If we're talking about the projects, for example, of 500,000 euros, actually, or KM, what would be the reason to use the FIDIC? And what would be the pros and cons, by your opinion? Jovan? You wanted to?
Yeah, let's say that progress of smart value, I would say that FIDIC would be best solution. Reason for that is simply as Senka mentioned, time-consuming procedures whereby administration works with FIDIC and for costs where you capital involved, associated involving engineering recycle volume of the main participant in this relationship between corporates on this tour. The other side, what we see as a real basically to apply FIDIC also in this situation, FIDIC is not with regularly applied, is to avoid negotiations for it. Contractors speak for finances, they're simply FIDIC think that yeah, guys selling to their hostile. So even though we have gotten to lower value, we apply FIDIC sometimes only to avoid this complicated negotiations with our financial institutions and negotiable stuff. In my personal opinion, wouldn't be my first choice, especially when you have local participants and local contractors serving.
Thank you. So we do all agree. Since I was preparing for this panel about a month, and I wanted to address the question that would be very interesting to the audience. So I had the opportunity to discuss the FIDI contracts with some of the judges. And the main questions that they asked me, how can we modify FIDI contracts to be in accordance with the local laws? And how do we interpret the FIDIC provisions in accordance with the local laws?
Oh, you have to do that. It's not the question whether should I do that. It's you have to do that. FIDIC forms are actually, let's say, based on common law system.
Correct.
So there are a lot of provisions that have to be and must be adopted with our local regulations. And actually, what I notice as you know, some manner in which the persons who actually deal with FIDIC like to do is, okay, so we have particular conditions. We have tried to modify the FIDIC forms of contracts in such a way that it actually aligns with the needs of the two parties, and also to align with the local regulation. But sometimes particular conditions are drafted in such a way that actually, after all these modifications, this is actually not FIDIC contract anymore. So you have to be very careful that the most important principles of FIDIC forms actually remain, and that they are adapted to suit the local regulation.
Thank you, Senka. And another question would be, what are the other challenges in implementation of FIDIC contract in accordance with the local laws? I would say that we all had at least one question from our clients which regards to the statute of limitation, which regards to the preclusion and claim proceedings. And we all do know that the statute of limitation for the damages in accordance with the Bosnian, I would say Serbian, also Croatian law is 3 years. But in accordance with the FIDIC contracts, for example, you have 28 days.
That is actually my favorite question. Thank you for that. Yeah, so there are condition precedent in FIDIC forms, which says that contractor has to provide timely notice of dispute to the engineer. And FIDIC form suggests that that should be done 28 days after contractor has become aware of the circumstances giving rights to a claim for money or time. So the question is, what happens if actually contractor failed to act in accordance with that requirement of FIDIC? FIDIC suggests that in that, if it fails to provide notice of a claim on a timely manner, the contractor will lose its rights. Okay. So empty pocket. And the question is that in accordance with our local regulations, with law and obligations? Because if the answer is yes, that would actually mean that we have changed the statute of limitation by a contract.
Did we?
Or alternatively, if that is not changing the statute of limitation, then it is that we have included preclusion in our contract. But the question is actually the same. Are we going to treat that as introducing statute of limitation, which is not 3 years, but 28 days? Or have we introduced preclusion deadline? Is that allowed? My guess is that that is not allowed.
Why?
because according to Bosnian and Serbian law, we cannot change statute of limitation periods. Only the law can set statute of limitation period. But the other question is, can we introduce preclusion deadlines which are not predicted by the law? And my guess is again that we cannot do that. And I think that we also have not explicit but implicit law provision that says that preclusion deadlines can only be set by the law.
Okay, thank you, Senka. I wanted to ask the audience to include into this discussion. If it's easier for you, you can speak in Bosnian. We will translate the question, so feel free to comment, please.
You would disagree with me, and I can't wait to hear why.
Please.
Okay. Hello, everybody. My name is Janita Osmanović. I'm attorney at law here in Sarajevo. I work in a law office, and I have a lot of experience with FIDI contracts, actually working right now on one DAB proceedings in Podgorica, Crna Gora. And I strongly disagree with my colleague.
Nice to hear that.
Why? Because I have been through various of, let's say, seminars organized by the FIDIC organization, held by engineers. And I had the opinion as my colleague before, but when you hear engineers who actually implement FIDIC contract on the field without the lawyers, this FIDIC contract, in my opinion, is strongly oriented towards the project itself and towards finishing the project and towards actually implementing the FIDIC contract in the field in the mindset of finishing this particular project. And in that case, I think the procedure of notice of claim, as well as the claim procedure itself, it's oriented towards the finishing the problems that's ongoing on the field. Because construction projects are basically guarded by the law when trouble comes in and when actually parties go to disputes. But even then, the FIDIC contracts stipulates that the disputes shall be solved by the DAB. And the DAB is usually also an engineer, in my practice, who also understands the aim of this contract. And in the sense of the lawyer, we should not see the FIDIC contract as, particularly from the law point of view, especially when we have in regard our
I'm
law
sorry,
and
but
obligation.
that would be hard because FIDIC is a contract, and as a contract, the law and obligations actually applies
Yes, I actually
on it,
had
so.
an ICC arbitration also on FIDIC, and this perspective is the one that arbitrators from Germany, Switzerland, and the third one was, I think, also from Europe, had also understood this kind of, let's say, provisions in the FIDIC contract. So I would say we should not look at this as a statute of limitation, this notice of claim. I should look at it as one, let's say, provision that guides people on a field how to react on a problem. That means this is contractual deadline that needs to be followed by the parties on the field. Why? Because if you notice a claim in the period that FIDIC contract is predicting, then you react to the problem at once. And of course, these are not usually law problems. It is not problems that we lawyers know to answer. These are the problems of the contract, of the buildings, of how to solve a problem on the field, which is usual in FIDIC contracts. So by us, when we lawyers come in and say this is not in accordance with the law of, let's say, regional law and obligation, we are introducing a very dangerous, let's say, point of view, which I think will be an obstacle for FIDI contracts on the field. And I think that this notice of claim, which is stipulated as a binding provision in a contractual sense, should be applied as that. Statute of limitations is guarded by some other facts that is going on the field when implementing FIDI contract, for example, IPC statements and so on. So that is my comment.
No. Thank you. Thank you, Senka. I would like, please short.
Just one sentence. As I understand,
na radio.
As I understand, you're actually suggesting that we should have some special interpretation of the law provisions when it comes to FIDIC contracts.
We don't have much time, and we're already late, so can we first hear Florian, and then we will continue at the Q&A session with this, okay?
Okay, no problem.
Florian, please, just a mic.
Anyway, I try to speak loud enough. Yeah? The prevailing view in Central Europe and certainly in Western Europe is that the notification is not the same thing as a fully particularized claim. So the statute of limitation would apply as regards the fully particularized claim that is actually filed, whereas the notification, the purpose of the notification is to remedy a delay event.
And I think this is the first distinction. And the second, if you look at the purpose of notifications, the purpose is to remedy something that hinders progress. So if you allow that to happen within 3 years, the contractor would be able to claim after 2 years, well, I have 2 years of delay because you were not providing the drawings or whatever. And that is a delay event, and I think that's not practical at all and not reasonable at all.
Well, maybe it's not reasonable. I can agree, of course. I can agree on that. But actually, when you have time limit to file notice of a claim or detailed claim, it doesn't mean that this deadline is actually meaningless. If a contractor missed the deadline, he will have the right to claim money or time, but he will also be liable for damages to the employer because he missed the deadline. That would be the right consequences under loan obligations. Not losing the right, not that harsh consequence, but right on damages, absolutely.
But I mean, isn't that turning it kind of a bit circular? Because if the contractor has a claim, or if the employer has a claim for damages, the employer will say, well, my damage is delay, so now pay me back my whatever you claimed. And
May I just jump in briefly as an engineer, make some brief observation. When we speak about statute of limitations, and please correct me if I'm wrong because I'm not a lawyer, we are speaking about damages. We are speaking about damages. We are not speaking about costs, which are defined by the FIDI contract conditions. So we should first distinguish what are the damages comparing to the costs, because each provision relating to claim says that if the contractor is entitled to an extension of time and or costs, which shall be included in the contract price, can we even then, from that point of view, even speak about statute of limitations? This is something that is bothering engineers, and I'm glad and happy to be able to address this here amongst all of you lawyers.
In accordance with our discussion, I have another question. First of all, I would like to hear your opinion regarding the role of the DAB, role of the DAB in dispute prevention, and another question would be, can we enforce the DAB decision? And how the DAB decision in fact affects the statute of limitation? Since we're pretty much late and there's a lunch waiting for us, I think these are very interesting questions for the practitioners and the engineers. So maybe we can continue with this subject.
Unfortunately, courts will not endorse enforcement of DIB decisions. And when it comes to the question whether initiation of DAB proceeding interrupts statute of limitation, there are two opinions, and one would be that it does, because it is the other authority before the authority
in accordance with the law and obligations
that you can address to resolve the dispute. And the other opinion is that DIB proceeding, initiation of DIB proceeding, does not interrupt statute of limitation, because DIB is not recognized by the law as the authority competent to resolve the dispute. And this is unlike, for example, mediation proceeding, which is recognized by the law as the proceeding for dispute resolution mechanism, and also arbitration proceeding, which is also recognized by the law as the proceeding for dispute resolution. So my guess would be that DIB proceeding does not interrupt statute of limitation.
Then the next question would be, why should we use DAB? What is the role then?
Because DIB decision is at least a good guidelines. How would your case be resolved in possible arbitration case?
Yeah, but I still didn't get the answer. My opinion, legal opinion, is completely different different than yours. Having in mind that in accordance with the main principles of the law and obligations, if we incorporated one of the mechanisms into our contracts, and we have to respect it before we go to the arbitration. As far as I can tell, I don't know the exact definition from the law and obligation, but as far as I can remember, the statute limitation applies to the procedure that are, I think, the front of the court,
or another competent
body. Sorry?
Before the court or another competent body. So the question that should be answered is...
Is it competent body?
Right.
I would say it is. Sorry?
To finally solve the dispute.
Okay.
And considering everything Senka said, I agree that this is not favorable position, but based on my experience, prevailing view in the region still goes in direction that initiation of DAB will not interrupt statute of limitation period. And just a very short remark, and it goes in something that Tanya said. You make a good distinction that we often as lawyers disregard, that when we talk about cost claim versus damage claim, there should be differentiation when we talk about start of statute of limitation period. And that is something we call, let's now put preclusion as such on the side. Let's talk about start of statute of limitation period. However, considering very broad definition of costs with capital C in the FIDIC contracts, it is often the challenge to make differentiation whether there is something that constitutes damage claim but is not encompassed with cost as defined in the contract. I have my views on that, but we don't have time, and this is not a topic, but happy to hear
We can
otherwise.
stay another hour here. Yeah. Thank you very much. My personal opinion, as I said, I do believe that DAB interrupts the statute of limitation. And I do understand that the the provisions of the law that states that it has to be made by the competent body. But the law and obligation here is made around 74. So we did not have the DAB as alternative mechanisms in the FIDE contracts. But as far as I can tell, in Bosnia, we don't even have one court decision in regards to this question. I don't know, the Serbia.
The same is also in Serbia,
also
but what do we
Serbia.
have?
Sorry?
What do we have is one arbitration award that deals with this question from the perspective of the Montenegrin law and obligation, which actually contains the same provision as Bosnian and Serbian law. And the answer was that DAB proceeding does not interrupt statute of limitation.
Yes, but we have to have, we have to have in mind that we're arbitrators, local legal practitioners, or they were foreigners. So it's very, for me, sorry for interrupting, but I know that most of you agree, but if somebody comes from the common law system, I'm not really sure that they can interpret our law correctly. Just like it's the same situation for us. If we are appointed as arbitrators for England law or any other law that it's not ours, I'm not sure that we would understand entirely what the law wanted to stipulate and how should we interpret the certain provisions. So before we rely on that decision, arbitral decision from Montenegro, I would just have that in mind, because we still do not have, as far as I can tell, any decision from the local courts, from the region, as far as I know, or any other arbitral decision, right?
I couldn't agree more. We do not have any court decisions. And of course, this Montenegrin award, Montenegrin-related award, that I mentioned is not publicly available. So this is just the information that I got. And of course that at least one of the members of the tribunal was a local lawyer, so this is probably a very important reason why it was decided like that. But when it comes to application and interpretation of Bosnian, Montenegrin, Serbian law, well, with all due respect, but I think that the right interpretation can only be received from the local lawyers. I wouldn't dare to interpret and disagree with my colleagues from England, France, and Italy. I would appreciate their opinion, because I believe that they know their regulations better than I can imagine.
Of course. Because we need to wrap up. I said this 10 times, but now I mean it. I would just like to ask one question, and that is for Taner. What is then the role of engineer in dispute prevention in accordance with the FIDE contracts?
The engineer is a third party which derives its powers and authority exclusively from the contract. He basically has a dual role. He acts, number one, he acts as the employer's agent while exercising specific duties and responsibilities under the contract assigned to him, such as while inspecting the works, recording or monitoring the progress, taking over certificates, etc. And another thing is that he is a decision maker. So when there is a disagreement between the employer and the contractor, there is an engineer who shall make a decision or issue a determination in order to resolve that disagreement. But the even more important role that the engineer must comply with before issuing determination is that he consults both parties in endeavor to reach an agreement. And this is his dispute avoidance role. So he must make extreme effort, consult with the parties, discuss with the parties about the matter at hand in endeavor to reach an agreement. If that agreement is reached, there is no more disagreement, there will be no escalation into a dispute, and this is the major and important role that the engineer has. When consulting parties, when issuing determinations, he does not he is no longer employer's agent. He must act fairly, in an unbiased manner, and his decisions or determinations must be fair and taking due regard of all relevant circumstances.
Thank you very much, and thank all of you. I hope you enjoyed this very fruitful discussion. I suggest that we continue over lunch and we can discuss the topic regarding the statute of limitation, of the claims, of the DAB, and the process of the DAB actually. So thank you once again. I think we will come back for 1 hour and 45 minutes.
Thank you.
Ladies and gentlemen, welcome back. I know the risk of choosing such a beautiful location is that also people will be tempted, as is absolutely normal, to gaze at the beauties of Sarajevo, but you will have a pretty long break after this session and our dinner tonight to fully enjoy the city the way you want to. Not
and you can gaze at beautiful people.
For a change. Now we have this again. Also, we are now tasked with facing a topic that is challenging for 2 reasons. Number 1, it's after lunch, and it's heavy. But another reason is that investor-state dispute settlement, which will be the focus until the end of the conference, has been described by many as a scam which has been sneaked into international treaties and is basically designed to allow foreign corporations to prevent states from regulating, but also to get money out of states. It is also apparently an obscure system, although we can't even catch up with all the awards and the readings, but it is obscure, and decision makers are corporate lawyers who are totally detached from state interests and any kind of consideration of any issue other than private issues. We hope after the session today you will not leave with such an opinion. We have a fantastic panel who knows diverse nuances of this system, and we will build on previous discussions that we have had throughout the years of the Sarajevo Arbitration Day Conference, where we have followed the evolution of these issues, especially the one on the Energy Charter Treaty, where we were very optimistic in the years before, and now we find ourselves before another vote. So you will be able to see the whole spectrum of issues that are available in this space. So before we start the discussion, I will not even attempt to introduce in detail our speakers. You will have their bios behind us here. Try not to be distracted as well, but you can also see them in the promotional materials for the conference. So with us today, we are very proud and happy to have a stellar panel of Professor Kabir Duggal, who is a professor of law at the Columbia University of Law, and also he comes from Arnold and Porter. So you will see that he has a dual kind of incentive and insights from that area. We also have with us proudly today Jelena Bazarević-Pajić, who comes from Šonher, and we will hear from her also on mostly the Energy Charter Treaty issues. On my left-hand side, for no reason other than we had to kind of divide our space, we have Florian Haugeneder, who is a partner at Knotzl in Vienna, and we have Mr. Radović from BDK in Belgrade. So with no further ado, we would like to kind of start from the basic issues. We talk about the reform of the system because of criticisms about the procedure. But we have to remember, every procedure is just a procedure. So arbitration or litigation or maybe some standing in the investment court is a process that feeds off of a legal framework that are built by states. And in this context, we have investment treaties as the fundamental source of issues. States have evolved in their opinion over the years of how they approach and how they see these treaties, but also how do they now navigate the broader legal spectrum in this space. So I would now open the floor first to Kabir with this small task. Can you please help us navigate?
Fix everything.
Fix everything and tell us how states are trying to fix it.
Okay, I'm going to have to use a microphone, which I've never used in my life, because I swallowed one of these when I was growing up. So can we get the PowerPoint? The PowerPoint? Okay, so welcome to the post-lunch session with the most beautiful people. And by beautiful, we mean appearance, not intellect. This is my 7th time in Bosnia, and I'm coming back again in 2 weeks. Many people say I'm honorary Bosnian, and I take that as a very big compliment. We have finally been able to get Professor George Bermann. We have been trying for 2 years to get you here. We finally made it happen, and we have to bring him back because we cannot show him Mostar. So we have that to look forward to. Just one final point. We're going to be talking about how do we build robust investment agreements, and this is important, especially for the Bosnians in the room. This country in the Western Balkans has actually been the leader. You can see Samira, Farooq, I think Alma is somewhere around. They have actually played the pivotal role for the region. I mean, it's one of those very interesting facts of life that the investment policy is actually coming out of this city with people like them. So talk to them. They may have a lot more to tell us. But why are we talking? What did I do? I think this was not turned on. I turned it on? How many times does it take a lawyer to figure a simple click button?
You can see it works.
Okay.
Don't shoot any.
Okay. Why are we talking about this issue? What is the problem? At this stage, it's not me. No.
The GIF is appropriate. We have a man one.
Yeah, that's my life.
Yeah, you can. No, you can start.
Sure. So why are we talking about this? Now there are 2 reasons why we are talking about this issue. Issue number 1: if you look at a lot of these cases, practically every case, you're going to see a tension between what we can describe as investment property rights and broader societal goals, human rights, environment, indigenous communities, and you're going to, there we go. It magically showed up. No, it didn't. Yes, it did. No. Okay. Here are just some examples to show this tension. And what tends to happen, tribunals, for a variety of reasons, tend to focus on the lex specialis, on the specialized law, which is property rights, investment rights. The net consequences, broader societal issues, may sometimes take a back seat. And this is significant, right? You think of your own country, right? You want to see development, but you also want to make sure the environment, human rights, and all these other societal goals are protected. That's one area why we're talking about rethinking investment agreements. The second is a historical point. How did these investment agreements take birth? Now, for all the history junkies in the room, the first investment agreement, this is 1959, was Germany and Pakistan. And when Pakistan gets sued, the Attorney General, this guy, goes to Google. This is 2003, so some credit, Google was still new. Ask Jeeves was a thing around at that time. He went to the internet and put in, what is an investment agreement and what is ICSID? Right? This is the reality, not just for Pakistan, although I think, as an Indian talking about Pakistan is always fun. This became significant because a lot of these investment agreements were signed without countries fully appreciating how much force these treaties had. I think his very famous sign, which is behind Fahira, so I'll read it out. We had a delegation coming. We didn't know what to do. Let's sign an investment treaty. And that's where we see 3,000 of these agreements coming out. So the historical evolution and the fact that tribunals tend to look at the treaty as the priority do give rise to some conflicts. Now, we put primacy on the states. Samira, I see Alma back there. Alma, Farooq, the pressure is on all of you. Because we are told time and again, the burden to get this right is primarily on states. You can see James Crawford telling us that, you can see Daniel Bethlehem telling us that, but we're putting primacy on the states. Get your treaties correct. So what should we be doing? And the first point, just to reflect what we are talking about, states. You need to draft your treaties better. You need to really put these human rights, environmental obligations in a much more explicit manner in your treaties. You need to make sure the jurisdictional and applicable law provisions are broad enough to get in all these broader interests, right? Because this is something tribunals often tell us, we can't do this. The applicable law doesn't take us this far. The jurisdictional clauses don't take us so far. So doing this will help. But we also want tribunals to do a better job. This is something I think Fahira has written a lot about. We have within our existing mechanism, Article 31(3)(c), which you can see on the slide in front of you of the Vienna Convention, which does tell the tribunal you should take into account relevant rules of international law, right? And this may allow us to look at the Paris Agreement, to look at human rights conventions, another mechanism tribunals can use. Now, what are countries doing? We look at some best practices, and we'll go through this relatively quickly. Fahira, anybody wants the slide deck, we can send it to them. So you have the examples. But what are states doing? States are now putting in better protections in the preamble, right? This is the fancy thing that every treaty begins with, that most constitutions begin with. States are putting things in, we are preserving our right to regulate. We are preserving sustainable development goals. You're explicitly telling the tribunal, this is our goal. Now, just to put everything in perspective, preambles have had a role in interpretation, but it is a subsidiary means of interpretation. Tribunals may give weight to it. You have to take this in light of express obligations. Preambles will take you far, may not take you as far as you need to go. Now, before we go on, just to give a regional example, this is the Treaty of Montenegro with Europe. At some stage, this is going to become moot when all the Western Balkan countries join the European Union. But till then, we can enjoy this preamble. They talk about the ILO, they talk about corporate social responsibility, they reference OECD guidelines. Now, for people who actually look at the OECD guidelines, the UN Global Compact, all of which are referenced, none of these instruments have in and of themselves firm obligations. So we may be getting into a circular problem, but life's interesting. So this is one thing, put things in your preamble. The other thing we are seeing, states are putting provisions that tell us we're not going to relax our standards. We're not going to relax health, safety, environment. You see provisions like this. We see them coming in with some frequency. Now here's the fun fact. These obligations often are restricted to the states. I just point this out because sometimes in the case, a state wants to point to this provision and tell investor, you should be doing A, B, C, D. But if you just look at the plain language, the obligation is every contracting party, the countries. So Is this an improvement? Yes. An improvement depends on what you consider the problem to be. This will fix certain problems, not every problem. Okay, you can put general exceptions. This is copied directly from the WTO, or very heavily inspired if you don't want to use copy. Okay, you see provisions like this coming up with regular frequency, right? Nothing in this treaty will, and then we put our list of favorite things, will apply to human rights, to life, health, environment, fun things like that. Now you would think this solves the problem just by looking at the plain language. We have the worst decision, I think, ever, Echo Oro versus Colombia. It finally worked out okay, but the interim decision actually tells us this clause excludes liability but not compensation. Which, if anybody in law school told you you could have compensation without liability, we would fail them for utter incompetence. Very prominent tribunal tells us this. Let us hope this was an outlier and the case dies and is never revived again. But Echo Oro stands out there as a very significant case. And I also just point out, Echo Oro, Canadian company, Canada, the investor's home country, itself wrote a statement saying this provision doesn't apply. So it's just one of those remarkable moments. Both countries said the provision doesn't apply, but the tribunal was like, legal term. You can add clarifications. Now this puts a lot of pressure on states because we are telling Samira, Alma and Farooq, every time an investment arbitration decision comes out, you need to read it, you need to digest it, and you need to put clarifications. Now for MFN, this is something George Bermann gave a keynote speech on, very, very controversial. We are now seeing footnotes being added, and the footnote really tells us one interpretation of the tribunal, the Maffesini interpretation, doesn't apply. Now, good luck to all the government officials. We think you have a lot of spare time, so we want you to read more and more decisions. You can put voluntary obligations on companies. And I think I should end my discussion just on that point. It is voluntary on companies. Obviously, companies are out there to do everything good on the planet. We don't need any regulation. I'm kidding. But it is voluntary. And we look at two large developing countries. So if you think this is a Western problem, this is Brazil and India. Clearly, the government officials there were smoking something nice. Both tell us voluntary. And finally, the Dutch. Now, they came up with the new model, BIT. They have put in obligations. They have put on obligations for themselves, not on the investor, which is again a great way to solve all the problems. We will not put anything on the investor. It's our burden to fix the environment, health, safety. Now, what is the key takeaway? The key takeaway is these are existential questions. I think Fahira started it telling us that. If we don't get this right, the existence of this system may be in trouble. So we need to get it right. States are doing improvements. How far these are going to go remains to be seen. So great moment to be alive. This is funny. And Fahira, I pass the mic back to you.
Thank you so much, Kabir. What a tour through all these experiments the states have been conducting so far. Listening to you and this very clear-eyed assessment of the solutions proposed thus far really clashes with the narrative that many of these proposals are already best practice, knowing that none of them have entered into force yet, nor have they been tested in practice in any way. So states are still conducting an intellectual experiment in a whole new brave world, talking about sustainable development, sustainable investment. How do you integrate enforceable provisions into treaties that are meant to guide, that are meant to, like you said, provide aspirational language, which even now, if you look at some of this more modernized language, still seems pretty aspirational. But I think this will also tie into Jelena's input, and we'll discuss a little bit more on that. I do have a question for you, talking about the terrible Eco-Oro decision. The proposal for the establishment of the multilateral investment court would also entail a harmonization of the jurisprudence. The goal is you have a court, you have a jurisprudence, you have precedent, and the appeals mechanism, which will allow substantive review and then the overall harmonization. If this court would come up with another Eco-Oro, what do we do then if the future tribunals also have to perpetuate this in this now very closed, self-supporting system?
Fahira, that's a great question. You and I have spoken about this, and I'm going to use this in a legal what I'm going to say is a legal answer. We are screwed. If the appellate body gets it wrong, and actually, you know, when you and I were talking, the US delegation was with us, and this was his point. You know, we're trying to look at the WTO and replicate the WTO model for investment arbitration. A big criticism of the WTO is the appellate body has just made up stuff that no state says was their intention, and now because it's an appellate body with this binding effect, we're stuck with decisions that really don't match what states are telling you they had in mind. And that's the risk we really have if this is the model we are going to adopt here. So, I don't know, I wish I had a more optimistic answer, but
we have to have.
No, I mean, optimistic answers are not necessarily constructive.
Yeah.
So this is at least a very sobering view and very true from this perspective. Again, if we had any empirical evidence, if we had 2 cases, 3 cases so far, but it has not been tested. And yet in the reform process, this is touted as the universal reform. It will fix everything from the conduct of arbitrators to the consistency of decisions, the cost duration, and we have a long-standing experience with the WTO telling us if you want to remodel this, you will need to invest more time to fix these things as well and not just arbitration. But let's put a dot now because that's a whole different bigger question. But thank you for just very openly addressing what it is, what it will be. And this turns us now to a very special kind of treaty. The Energy Charter Treaty, the only multilateral treaty that regulates and sought to harmonize and facilitate the trade and investment in the energy sector, which was challenging at the time when it was adopted in the 1990s, 1994, where Eastern Europe was opening up for such investments. And the Western world was, we have to use these terms in this context, was turning towards them, but either not trusting or not knowing what their legal system is. And it was adopted as such and for a specific purpose. But now, as Kabir was mentioning, although there are some provisions in the ECT that allow and encourage considerations of the environment, the safety, and the sustainability, they are not up to par with the Paris Agreement, according to the loudest critics. So the ECT now, and that will be our shorthand for the next few moments, the ECT is criticized and scrutinized for 2 main reasons. Number 1, and this is mainly from the EU, it says it is absolutely inadequate for the Paris Agreement goals. It is obstructing it, and it's better to do away with it altogether, although their proposals for the modernization were largely adopted.
Yeah.
But the second reason is that the vast majority of the recent energy disputes come from investors in the renewable sector, still governed by the old energy charter.
Ironically or not.
So we will have to kind of address also the terminological issues now that are arising. But before that, again, very easy task. Jelena, thank you for taking it on. Just take us through what's wrong with the ECT, what can we use to fix it, and where do we stand now?
Well, good afternoon, everyone. It's truly a pleasure to join this esteemed conference, to be among such distinguished colleagues today. From the very rich discussion we've heard so far, I can sense a very dynamic energy within this arbitration community. And I'm kind of sure now that our panel will also continue to spark engaging and insightful dialogue. So as it was mentioned, my role today is to dive into the Energy Charter Treaty, or so-called ECT, a topic that has not only steered the heated debate among the arbitration circles, but has also attracted much attraction, much beyond that, even reaching the public discourse. So this treaty has gained a prominence as the single most frequently invoked investment treaty for investor protections. So this very feature, ironically or not, has made it actually a lightning rod for criticism. In fact, it stands as one of the few treaties where even its key architects opted to walk away. So in the following 10 minutes, I will try to briefly walk you through these key aspects behind this treaty, including what this treaty is about, what challenges and developments it has faced, why it has drawn so much critics, can it endure, and finally, what alternatives exist for those who are left without its protection. So to keep things lighter, at least a bit, and visually engaging, I have some... Yeah, I have some cartoon illustrations that will run behind my presentation. So the illustrations are AI generated, so I challenge you that you watch them and find hallucinations, and we can talk about that after this panel. So if we start with the question, what is the ECT? As Fahira mentioned, this is the multilateral investment agreement that aim to promote international cooperation in the energy trade, transit, and investment. So while its scope is definitely a lot broader, what's most relevant for us today is its role in protecting the energy investors. So ECT offers, much like other bilateral investment treaties, safeguards for the investors. So ECT offers substantive standards of protection and also dispute resolution mechanism, and within that the most important is the right of the investors to have their dispute settled before the international arbitration. So a little bit about the historical background. It was signed in 1994 and came into effect in 1998. And what is important is to have in mind that at that time fossil fuels and carbon-intensive industry were dominating the global energy landscape. And at that time, it was really important to have the cooperation between the Western Europe and the former Eastern Bloc. So at the beginning, ECT was really focusing on the Europe, but very soon after that, it expanded to cover also the non-EU countries. So how ECT actually developed? So as we said, originally, the ECT was created to protect energy investors, including those investors in the carbon-intensive industry. So the global energy landscape changed. It moved towards the greener solutions, and the climate change became a pressing issue. We have a Paris Agreement which set very ambitious goals for fighting against the global warming. And what is important to mention is that 195 countries signed the Paris Agreement, that they committed to combat this climate change. And if you can really notice, I think it's obvious that this is the unprecedented wave of environmental protection. At this wave, actually, United Nations states like never before. So in parallel with this, after this Paris Agreement, states became invoking measures, restrictions. So we now have the pictures behind me. So the picture which should illustrate what is the ECT. So development. So after the Paris Agreement and also along with the Paris Agreement, states introduced measures, restrictions and bans in fossil fuel and nuclear energy, and investors turned to the ECT for protection. So after that, arbitration claims under the ECT began to surge. Investors started challenging these new regulations. So in 2024, ECT became the most frequently invoked international treaty. There was 162 cases where actually ECT was involved, and in many of these cases, states lost, and the amount of damages were huge. In some of them, we saw even the damages highest ever seen in the investment arbitration. So, ironically, as Fahira mentioned, even renewable energy investors started to use the ECT to sue the states. So, for example, Spain, Italy, and Czech Republic found themselves in the ECT arbitration after they modify or revoke incentives for the renewable investors, so often due to the economic or other policy reasons. So, to make these issues even more complicated, at least for the EU, following the Armela ruling, where the EU took a standing that, as we all know, that the intra-EU BITs are not compatible with the EU. It wasn't long after that EU also took a standing that ECT is also inapplicable in intra-EU disputes. So despite this, arbitration tribunals did not, in most of the cases, did not agree with this standing. So this also creates a further complexity with the ECT and uncertainty for the future of the ECT. So because of all these issues, states began reassessing the ECT, and it became obvious that the original text needed the reform, and the reform really urgently. So the modernization talk kicked off in 2019, with the EU, of course, leading the charge. And it took 15 negotiations around while they actually reach a draft modernization or the agreement in principle. That was in June 2022. So the modernization was centered around the following key issues. The most important was to phase out the protection for the fossil fuels. It was also important to introduce the climate-related provisions into the ECT and to make it more aligned with the Paris Agreement and with the climate goals. And of course, it was really important to modernize the controversial dispute resolution system. And after all, EU wanted to make sure to have the explicit provision that the treaty is not applicable between the members of a regional economic integration organization. But the biggest problem with these international treaties, and in particular when we have a multilateral treaty as we have with the ECT, is the complexity of negotiating with so many stakeholders. So it was really difficult to align the diverse interests that each of these states was actually trying to follow. So although the modernization draft was set for the voting, the protests were starting to going over and over, and although the draft of the agreement in principle was over, some of the states were not satisfied. They wanted more. They thought that even the draft was not aligned with the principles of the Paris Agreement. So some of the states, firstly Germany, France, and Belgium, actually firstly Spain, Netherlands, and Poland, announced that they will exit the treaty, and they also were followed by, soon after that, by Germany, France, and Belgium. So because of that, and of course, this domestic pressure, European Parliament did not vote for the agreement in principle. And after that, the EU decided this year in June to withdraw from the ECT. The Commission decided to leave the option for the individual member states to stay and to vote for the modernization of the ECT. So when we now hear what happened, it is of course okay, magic. We need some magic now.
As we're pointing, wave it, and then
yeah.
The wand is not working.
Yeah, the magic does not. The magic does not work. But
you can speak. I will try to do it.
So, what are the potential scenarios? ECT is still alive. It has 49 states at present. Definitely departure of, by now, 9 EU member states, and the EU casts a serious doubt on the future of the ECT. On the other hand, it is also possible that ECT will survive the crisis and focus probably on some other regions like Asia or Middle East or Africa or Japan. In my opinion, the future of the ECT will depend on its ability to adapt to a completely new reality, in particular in terms of these environmental pressing goals. Before I finish, I would just like also to mention a little bit about the alternatives. The alternatives that are left for those who are now found themselves, for the investors that found themselves to be without the ECT protection. It is important to know that the withdrawal of the states from the ECT is not effective automatically. So they have 1 year from the notification of the withdrawal until the withdrawal actually takes effect. Besides, there is also, luckily for the investors, the sunset provisions in the ECT, which provides 20 years more for the existing investments. Interestingly or not, we have to mention that, of course, EU has a separate standing on this issue that, much like the ECT, of course, the sunset provision in the ECT is not applicable. So we'll see. There are different opinions on that and whether the ECT actually did it correctly when it wanted to actually displace also the sunset provision from the application in terms of these intra-EU disputes. So besides the sunset provision, of course, the investors should take a look and really see whether other investment treaties are available for their protection. For example, for the UK, there are like 85 BATs or other treaties covering the investment protection applicable. So they would be definitely advised to take a look and also, of course, to consider restructuring their investment to maintain the protection in the event of disputes. And of course, I think that the investor should always think whether it would be possible to incorporate some contractual safeguards to keep their investment well protected. For the conclusion, I will invite all of you to think about these developments and, of course, keep an eye on future development of the ECT.
Thank you very much, Jelena. Again, this has been decades of conversations and reforms and application in cases, so thank you for really capturing the essence there. And always when I listen about these issues, I have several thoughts that will never be resolved. I will probably never get an answer from the EU, but you mentioned that they were kind of reconsidering the ECT. They're basically they want it to go away. They want the ECT to go away as if it never happened, the sunset clause never happened. And there's a lot of terminological misconceptions, because now the activists and people who are very openly against the ECT use all these cases as the same, as if the renewable energy cases and the fossil fuel cases come from the same place, the same thing, which is obviously not the truth. And in recent years, the vast majority of cases, you mentioned the Spanish saga, which is now almost above 60 cases. We have enforcement issues that we will talk about in a moment. Not every case that is in the energy sector is a climate change case or an environmental case. It is mostly a matter of compensation for actual losses or losses that they have anticipated in the near future based on what was promised to them by the old regime. Now, the newer Energy Charter Treaty, and this is the second conundrum for me, and we will even try to debate this because the EU will never tell us. If you have the old treaty with a 20-year sunset clause that says, we are leaving now, but the existing investors will be protected for 20 years. You have the modernized treaty that says, you can start phasing out fossil fuel protections immediately, and the sunset clause is 10 years. What is the benefit of exiting out of principle or out of some sign of taking a position that you leave the old unreformed treaty and you don't allow the new one to take place and take hold? And what can the Western Balkan states, when they're making now the decision about voting in November,
joining the ECT or not, exactly.
In November, what do? Do you stay? Do you leave?
Well, I think that it is always better to have the investment treaties. It is always better to have the rules, because no matter what we talk, the states still need investment. They still need foreign investment. They need even foreign investments for the transition into these cleaner energies. So, but in order to have the new investments and the new investor coming, you have to provide some kind of safeguards for them. So the investors will keep counting on the safeguards and the protection. So the Balkan, especially, we will still need to have the investment treaties, either bilateral investment treaties or the ECT or some other. So I think the ECT and the bilateral investment treaties still have a long future in front of, but it will be important definitely whether like the investment law in general will be able to adapt and to respond to all of these criticism that is like growing and growing.
Thank you. So before we wrap up this treaty-based part, that is kind of the legal foundation for what Florian and Relja will be talking about, I have a short follow-up for both of you, and then open up maybe to the co-panelists and the audience if you want to kind of just address anything from the treaties before we move more towards the cases and enforcement. So we have heard a lot, and you can read a lot. You just heard from me in the beginning some of the bombastic titles of how bad this is. But looking at the modernized provisions that have many, many strong, sustainable solutions, and also a mechanism for state-to-state states to address amongst each other how they want to enforce this. Can we see a day in the near future, maybe, where the ECT can become an ally to renewable investment and sustainable development, rather than this obstacle by default, by the way it's designed or by the way it's applied? We don't have clear answers. I'm not asking you for that, but just your thoughts, if you don't mind.
Well, I hope so. From my personal point of view, I really hope so, because I think this is the new reality. Now, as we talk about whether it will be possible to reconcile the investment treaties with these environmental goals, my brother is talking in Vienna on another conference, the title of which is Balkan Nature Talks. So they're talking about what states further have to do in order to respond to adequately and to safeguard the planet. So I think, and I wish that day will become sooner the better.
I agree pretty much with what we have heard. One of the big ironies is the reform was an EU-led initiative. They dictated a lot of the policy. Florian, maybe you can tell us what happy product people in the EU were smoking, because it clearly was something nice. There is some amount of hypocrisy here. This was an agenda that they had dictated. Some of the ideas that they're coming out really seem lopsided and counterintuitive and really seem protectionist in ways that when other countries had made the same argument were dismissed by the EU as being primitive, backward. Latin America had been saying this for decades and no one took them seriously. It's just we have a very powerful bloc that is dictating the policies. Could it? I think, yes, we would like to see some form of it remain. Is it likely? Probably no. I think EU is committed to seeing its slow eventual death.
Investment treaty arbitration in general, so I don't think that...
Yeah, no, correct, 100%.
That's what we said. They wanted to disappear. And now we have to find a policy that will allow us to do this. But I think the key point, just like you said, it is about who is speaking rather than what is being spoken or presented. So we will have to wait for an answer from them from that side. Any questions or comments from the audience at this point?
Thank you very much. I'll be very quick in my comment, not to use too much time of the rest of the panel. Thank you very much. It is super interesting for me. With regard to the ECT, Jelena mentioned that it might live as a treaty that covers Asia or, I don't know, some other countries. Even if it happens without Europe, the ECT doesn't have that role or importance anymore. So, I mean, it can live just to live, but I don't think it would have the same importance in the world. And this is a question that you might be interesting to give me an idea of your thoughts later on. You don't have to answer it now. There is no scientific relation established between inflow of investments and treaties that have been enforced. So my question is, why do you think the other contracting parties, it's not investors, it's the other contracting party that is at some point also the host for some other investors, insisting on having BITs when they have arbitration, very strong arbitration clauses in commercial and investment contracts?
Great question.
Thank you.
Yeah, it's a great question. So, well, and it's interesting, and of course, it is always a question like which country is exporter and which country is importer of the investments, because the incentives for the modification of the treaties will not be the same. Well, this is maybe the issue and the problem with modifying the existing treaties, but definitely the existing treaties also have, like these final provisions, and they have some duration. So I think that states should carefully follow when these treaties expire, and at the time definitely they will at least have a choice to decide whether not to continue, and then to, of course, to start the process from the beginning with their new model BITs that I can really see that, all these countries in the region, they are really making the process better, and they are trying actually to have like a much more modern BITs than they used to have, unfortunately, in the past.
I'll just make a very quick reaction here. 100% in agreement. We don't have a consensus on what role BITs play. Now, typically you would say foreign investment. Economists are divided on that. Your people cannot agree on that. We say rule of law. Now, The world seems divided on whether rule of law is protected. We don't have a consensus. This is something George Bermann and, I think all of us at Columbia have. You knew I was going to get there. But this is something we have been talking about. Actually, we are looking, and to the extent you want to talk about the future may not be a world with investment agreements. The future may actually be a world where we are going to see investment contracts containing investment protection. That just seems, if the EU is as committed to destroying the system as they seem, this is the best we can do. So, this is my optimistic take. Florian seems to have a reaction.
Just a very short answer to that question. Yeah, there are many investments where you don't have adequate contract protection. Yeah, assume you have a German private investor coming to Bosnia and Herzegovina, complying with all the permits and building a solar energy plant. There is probably, there is a contract with the local people and with the landowners and construction companies, and you will have administrative permits and the like. You will probably not have a contract with the state if the state decides to outlaw solar energy for whatever reason from one day to the next. So that is a situation where contract protection will not work. And in my experience, and I will come to that in my short presentation, actually this is a very frequent situation in new energy projects.
Thank you all. I mean, this is also a whole conference for itself, all of these topics, but it's important just to indicate so many challenges in a system that seems to be, for most people, black or white, good or bad. It's not. They need to understand fully the practical implications, but always, always consider the state's perspective as well. Because these policies, they're like turning around a tanker. It's not a speedboat. It's not the amendment of a contract. You really have to be considerate every time you propose something in your negotiations with the other state. That has to be in place for a long time. So everything has to be considered more broadly, and I think you have set things up perfectly for the next part of the discussion, which will turn to, well, the main point. If you engage in a dispute about an investment in any sector, what's the main point? You want an arbitral tribunal based on, for example, in these cases, a treaty, to decide your issues, and if there is something to enforce, you want to be able to enforce it. Now, the legal framework stands. We have conventions, we have treaties, binding obligations on investors, on the states. In courts, it's not always so smooth. So the second part of our discussion will talk about, firstly, what do we need to look at when it comes to disputes themselves? What do states and investors need to consider? Where do these landmines fall, and then how do they play out in arbitration that we have seen so far? And then in the end, Relja will turn to catching your money, chasing it around the world, the way that the EU is making all of their renewable investors now run around from the US to Australia to get their Spanish awards enforced. So without further ado, maybe we can start first, Florian. What is it that everybody needs to be mindful of from the body of case law we have so far?
Well, I will also thank you, first of all, for inviting me to this conference and to give me the opportunity to speak in such an historically important and beautiful venue. I will be speaking more generally about the lessons learned from energy disputes in the Western Balkans and beyond. And I will, as a kickoff of our later discussion, I will make 5 submissions, 5 more general submissions, which will partly address some of the points you've raised, and probably I'll have partly different views than some of the discussants. First, the key takeaway when you look at the present energy and investment market is that the transition to decarbonized energy requires very, very significant investment. Just an experience from Western Europe, I looked it up this morning. In the first 3 months of 2024, Austria has installed solar capacity of 500 megawatts. If you extrapolate that to the entire year, that's about 2,000 megawatts of installed capacity. And that's roughly the same installed capacity as all the hydropower plants of the River Danube in Austria, which is quite a lot. So just to give, by way of comparison, the investment, and that's hugely private investment, is huge, and that is was needed to achieve the goals of the Paris Agreement. And of course, I know that solar energy is not fully comparable to hydro energy, and hydro energy is in some ways easier to handle, but still it gives you a measure of the importance. Second, and that's also quite visible when you look up the reports on the energy sector in the Western Balkans, the current energy investment in the Western Balkans is not nearly enough to reach the climate goals. And according to my experience from investment cases in the Balkans, the reason for that is to a significant degree a lack of stability of the regulatory regime. Yeah, and that doesn't only concern, it's not, you don't have this as a binary issue between fossil fuels versus green energy. You have that to a very significant extent within the sector of green or at least decarbonized energy. And that is, that actually shows that first of all there is a big obstacle to sustained investment in the region, but also there's a huge opportunity if you look at the bigger energy firms in Austria, in Germany, Switzerland. They are looking for investment opportunities in the region, actually desperately looking for investment opportunities because the capacity for renewable energy, and in particular hydropower, is exhausted in Austria, in Switzerland, for instance. So I think the stability of the regulatory regime would be a key factor of attracting new and green energy investment. Third, investment protection in general, but investment protection in the energy sector is very much concerned about the stability of the investment regime, and that is particularly so in very long-term projects such as hydropower. Hydropower plant has a lifetime of 50, 60, 70 years, and of course it's a huge investment at the start, and operators are usually not calculating with a return on investment in the first 15, 20 years. So the stability of the investment regime is vital, in particular for such projects. And I would submit that ISDS would be a key factor in safeguarding the stability needed by the investors to attract those long-term and very significant investors. And as you all know, the Balkans have huge potential for hydropower, wind power, and solar energy. Fourth, there is, however, a widespread perception that investment protection, and particularly the ECT, is actually a threat to energy transition rather than an incentive. And I think this view is simplistic and not accurate. A change of the regulatory regime alone doesn't construct the producing capacity for energy. It just changes the regime. If you don't have the investment, you will not have the energy you need. So there needs to be a sustained investment policy to allow transition. And I would argue that that ISDS is primarily concerned with stability. ISDS and also the old energy charter treaty, I will come to that in a moment, but also the old energy treaty would allow to be used as an incentive for very significant investments. In this context, I'd like to distinguish between, or I'd like to take issue with this binary distinction between good investment, green investment, and not bad investment, polluting investment. Yeah? That's actually not the case. If you look at investment into renewable energy, that also has an impact on the environment, because you are constructing a hydropower plant that has an impact on the environment. You constructing a solar plant, you're constructing a wind farm, and all that is not without impact, and also it also needs to be regulated. So this goal, or this idea of putting policy goals into investment agreements is actually something that I see quite critical. And that leads me to the fifth point and to my conclusion. I don't think investment arbitration and investment arbitration lawyers should be policymakers. And when policymakers should be the state, should be the elected parliaments. And when you presented the issue as a tension between stability and broader societal goals, I don't think this is how it should be exactly framed, because the tension is between stability on the one hand, which is needed by investors, and a reasonable regulatory flexibility and legislatory flexibility for states, and that is neutral. We don't need to have very lofty goals about protecting the environment and about green commitment to green energy in the in investment treaties. The key would be in my submission. Would be to find the right balance between, on the one hand, the stability of the investment regime, but on the other hand, a reasonable and legitimate margin of appreciation of states to change their policies. The obligation to compensate for certain abrupt policy changes may exist even for fossil energy projects. Yeah, if you take the example of nuclear energy, the Vattenfall case. Yeah, if you invite an investor to build a nuclear power plant, which we know has a lifetime of probably 40, 50 years, and after a few years, the state says, well, in order to change my environmental policy, I now have to order the stop of operations of that plant. That may be a legitimate decision or not. It's a policy decision. Yeah? But the investor who has invested millions or probably billions into that plant should, I would submit, in accordance with the rule of law, be compensated. So I would argue that the inclusion of these policy goals that you have mentioned should be viewed with a lot of caution. I don't think they are necessary. What is necessary is the right balance between the right to regulate and the stability of the investment regime, which cannot be completely rigid, as we know, but on the other hand, needs to take into account the legitimate expectations of the investors. And that is, I think, the task of tribunals. I'm not in favor of having ever more detailed definition of what legitimate expectations means and what it doesn't mean. It's something that ultimately needs to be decided by tribunals having good judgment, as Professor Bermann said this morning. I don't think there will be any substitute to that. Thank you.
Thank you very much, Florian. It's very interesting to hear this perspective, actually, how these things do come up and surface, and it's absolutely not a simplistic view that happens in practice. Usually I'm also puzzled by the interpretation of, what is this right to regulate by the state? Because if we look at it from the perspective of simply changing your regulation, you want to make a new move, the fact you might have to pay for compensation does not mean you are unable to regulate in your public interest. It just means you are still bound by your international obligations if a specific investor or a specific claimant in a case can access these rights based on the previous regime. Does not mean that you are losing your right to regulate progressively as it should be in the future. Would you have any comments on this?
I would have a lot of reactions, but I will let Florian speak first.
Me as well.
Yeah, okay, but I'm kind of reminded of, Ford telling us, you can select any car as long as it's black.
Yeah. Now, I think I think that the regulatory regime, the stability and of the regulatory regime should be, I would submit, primarily be focused on the notion of proportionality. So you have, and that comes, and that's probably my constitutional law background, yeah. But I think it is a quite wise notion. There isn't. I mean, you have of course. Nobody has ever questioned the right to regulate as such. The question is whether the regulation is proportionate to the pursued policy goals. And I would submit, of course, climate change regulation is a very, very legitimate policy goal. It does probably not. It does probably not include the right to ban fossil fuels from one day to the next, especially if you have invited investors to develop fossil fuels just a few years earlier. And if you do that because you think there is such an urgency, then proportionality would require you to pay compensation for that.
And just to transition to Kabir, absolutely this perspective that, and it comes from the different narratives. Yeah. Because those who are against ISDS and the system will say, this is hampering states from regulating, and that's point blank for them, and these are the louder voices. But if you read these awards, you will see, number one, the investors, renewable or fossil fuel or any kind of these disputes that are emerging, they come from the perspective we are owed this money based on what was promised. They do not challenge the legitimacy of the policy. And the tribunals go at great length to say, we understand, and by no means is this a case about whether the state should change, are these good policies and how they want to regulate their public interest, but we are looking at what is due under the old system. And there needs to be a clarity about this narrative before you actually discuss. So I'm very happy that you brought that sobering also perspective. Kabir, please.
I think Yelena wanted to... Yeah. That is the risk.
How? But see, maybe it's my interpretation, but how is it regulatory chill if you are simply still due, if there's understanding that you are due something that's no longer in your control because it was agreed?
Well, well, nobody's questioning the state's right to regulate, but the problem is that actually states still, it may change a law, but it still should compensate the affected investors. So that is the problem. The problem is, of course, the goal is to have the balance between the state's right to regulate and on the one hand, on the other hand, the stability of the regimes, which is guaranteed to the investor. But the problem is that the perception that the current rules, the old BITs, do not transpose these balance correctly for the states. So, and also maybe in terms of it is important to mention in terms of the ECT that the ECT does not explicitly mention the state's right to regulate. So that is the problem, and I think
the modernized version would.
The modernized version, yes. So that was the perception is that you need to provide more explicit rules if you want to make a better safeguards for the states, in particular in the context of a sort of unpredictable results that we are all of a witness that may come up in different cases.
You know, see, one of the tensions we have, I think, comes out nicely from this panel where reasonable minds can look at same situations and have very different takes. You know, for me, we can judge, we look at what has happened to judge the future. And if we look at how tribunals have looked at BITs, it is a complete mixed bag. You know, I think, Florian, your descriptions were very interesting because you put an Austrian lens on how you were looking at the problem being solved. Now, this is the very interesting fact. Many reasonable minds may not put that lens or may not have that appropriate lens. And this is why we need much more explicit articulations of goals. We cannot just have 3 sets of people coming here and telling us, in our vision, Bosnia should be doing what the Austrian system can do. I mean, that is fundamentally the problem. And telling the fact that, oh, you can do what you want, but just pay money. And if we're talking about monies that can bring countries to their knees, is that the kind of investment Bosnia needs? Is that the kind of investment Serbia needs? I just posit that as something for us to think about.
If I may just comment on that. I said that the notion of proportionality was very strong in the Austrian legal tradition, but it is also in the tradition of public international law, as Professor Schill and many others have written, and there are many awards that have applied in cases of expropriation and FET. The notion of proportionality, and in particular, if PL versus Poland was a case that was primarily decided on proportionality. So that is the first answer. So this is not an Austrian idiosyncrasy that I try to expand to the world of investment treaty arbitration. It is already contained in public international law. That's the first answer. The second answer is I disagree, if that is meant, with the proposal that the regulatory powers of the state include the power to do whatever the state wants. Also, in our normal constitutional regimes, the state power to regulate is safeguarded by constitutional rules, by other rules, by the rule of law, in essence. and therefore there is not complete freedom for the state to do, or for legislators to do what they want, and certainly not for the administrations. And I would think it would be counterintuitive if we all have these checks and balances in our own constitutional systems, but we would allow the states complete freedom to legislate whatever they want at the level of international law. And the third point, the point of regulatory chill, I agree with you that the compensation awarded by a few tribunals had the effect of regulatory chill. I would submit that the primary mistake of those tribunals, and I'm not, of course, I don't agree with all the decisions that have been rendered. The primary mistake was at the level of compensation, where sometimes I think that the compensation awarded for probably speculative investments or investments that were at a very early stage was just disproportionate to the value that was taken. And I think here lies the real issue, but not at the level of liability.
And so important, generally, you can see how it can be teased out from very many perspectives, because none of these issues have been put on paper before in the treaties, and now this is what the policymakers, we have many of them with us today, this is what they're grappling with. And they have to now also capture these perspectives, but just because of the way a certain issue is phrased, a simple follow-up has already generated different answers, legitimate, but still obviously there's a lot of harmonization that needs to happen of the voices, understandings, and this kind of dialogue between all stakeholders, and states and investors, their counsel, their in-house counsel. This will all lead to this new generation of treaties, and different, not necessarily better, we don't know, better awards in the future. Any other comments before we?
I think, reasonable minds are going to disagree. I'm never going to be able to convince you. You're never going to be able to convince me. I'm going to tell you Jan Paulsen's famous line, if an investor is going to Switzerland, he's not going to Swaziland. Go with your eyes open. You know what you're getting into. This is your calculated risk. We're fundamentally not going to agree, and that's life.
Well, that's not what we're seeking today. We'll definitely have open discussions also from the audience for future comments. But I'm very glad that at least we have now shown in very broad demonstration how challenging this is. So never think states can simply regulate, never think lawyers can simply do a better job, or investors can do a better job. It's a very treacherous path that needs to be treaded carefully in the future, but let's see how it plays out in future conferences. So before, I know many people are looking at us as an obstacle to join others outside in the beautiful city, but we will now address another important issue before we close. We have come to the arbitration is over, we have our award, the investor won. What do we do next if the state is not compliant with an award? What's happening in the jurisprudence? Explain to us, please, Relja.
Yeah, now I can talk till the end of the session, right?
The easiest question always in the end.
Just before I move to, because my topic of enforcement is quite different from the three previous presentations, I just want to add two short remarks to this very heated debate. I think the first mistake of critics of ISDS regime is to look at the ISDS in complete isolation from the rest of public international law. And if you raise some issues which seem quite reasonable, such as lack of clear definitions of legitimate expectations and similar, those same issues exist elsewhere in public international law, and they're not contested as in ISDS. Why no one criticized the European Court of Human Rights for not defining legitimate expectations, which is extremely used in Article 1 of Protocol 1 to the European Convention? Because, of course, the value of claims are not so valuable, so of course you cannot make, the stakes are not the same. But it gives you an example that some standards of protection require some sort of abstraction and to be left to judicial pre-assessment in order to actually work in practice. I'm quite skeptical towards this solution. We need more and more regulation. I come from a country where we have very serious inflation of legislation, where answers to every societal issue is found in more and more regulation. It doesn't work. More regulation means that actually people will be less informed about regulation. They will not implement it. And I really see more so, I tend to believe that solutions are possible in more integration of judicial reasoning than more and more regulation. Just to give an example, and I want to actually give a bomb here to challenge to what Kabir said. I'm really, really skeptical towards including human rights protection investment treaties. I really believe that those provisions would, okay, we have a tour, that such type of provisions violates the philosophy of human rights as such. The first principle of human rights law is that the weight on enforcement of human rights is at the national level. And if states fails to enforce human rights at national level, that's its own fault, and that's where the state failed, not the investor, the state failed. If states already now cannot sue private individuals or companies in European Court of Human Rights, why they could do so in ISDS? So that is something that I would just like to add to this previous discussion for the sake of open and good discussion. But now let me finally move on to the final topic of this panel, and that is the enforcement of arbitral decisions. I especially want to thank you for assigning me this topic because it takes me back to my previous life when I was working in academia researching the practice of domestic courts in ISDS cases. So my talk will be more scholarly than practitioners because we are now, I'm going to focus on intra-EU cases, and we are now outside of the EU, and we are assessing possible effects of this caseload to our region. The topic of enforcement does not have much to do with the substantive energy aspect as such. It concerns more technical issues and technical aspects of arbitrations, and that is kind of reasonable because after the merits of cases are closed, you cannot reopen the merits, and you can only hope to reopen some very procedural aspects of arbitrations, which you could hope would prevent enforcement. Having that said, we need to start from the point which has caused all the problems in the sphere of enforcement, and that is the original sin of the Court of Justice of the European Union, committed in 2018 and 2021, when it stated it issued 3 judgments in cases for preliminary rulings, stating that intra-EU arbitrations are not in compliance with EU law and therefore precluded, I emphasize this word, precluded by EU law. I emphasize this word because it doesn't make any sense whatsoever from the point of view of law of treaties. But I wish to be very clear and very sharp in this respect. You can disagree with me. It is my personal view that Court of Justice of the European Union was wrong. That these 3 decisions have nothing to do with proper sound judicial reasoning and they're exclusively expression of a policy aim to internalize internal EU investment disputes. And I would submit that this policy element was so strong that the proper avenue for its expression would be legislative, not judicial, as in the end actually showed with the conclusion of the Treaty on Termination. But it is what it is. Out of these 3 decisions, the worst one is Comstrom versus Moldova, which actually addressed the Energy Charter Treaty, is the worst one because it concerned an extra EU dispute. Ukrainian investor against Moldova, neither of them is in the EU. The question referred by the Paris Court to the Court of Justice of the European Union concerns definition of investment. Despite of this, the Court of Justice issues a decision about non-arbitrability of intra-EU cases. Obviously, that's a very, very, very big decision which doesn't deserve any precedential value. But it is what it is. The reception of these decisions by national courts was quite mixed. Obviously, EU courts were more obedient to these rulings than non-EU courts, and this kind of makes sense because EU courts are, they form part of the same judicial structure as the Court of Justice of the European Union. But even within the EU, there were some inconsistencies. So, for example, there was a very famous clash between the Berlin court and the Court of Cologne about whether the Comstory decision actually also precluded exit cases, or was it limited to non-exit cases. This issue was finally resolved last year by the German Federal Court of Justice, which actually said that it does, and that therefore intra-EU arbitrations are not admissible. But outside of the EU, the issue appeared as well, mostly in the cases of recognition and enforcement. This is where we finally come to my topic. Obviously, the first question is, what jurisdiction prescribes what mechanism of enforcement? And this differs from state to state. For non-exit awards, obviously, there are more opportunities for reopening procedural aspects of cases which hopefully could prevent enforcement, hopefully for states, not for investors. Simply because in non-exit cases there is still recognition which is required before enforcement. But even in respect of exit, which by virtue of exit convention should be enforceable immediately, there are still some opportunities to reopening these procedural issues because some states still have either requirement of registration or the French word which no one knows how to pronounce, exécuteur, which should be obtained as a special judicial decision prior to enforcement. And although these proceedings are actually not required, they're not meant to serve as another opportunity to reopen procedural aspects of decisions, sometimes domestic courts are actually tricked into doing so. And the case in point is actually Mikula versus Romania, where before English courts the award got registered, the state appealed, claiming, the commission got involved, claiming that the intra-EU BAT was not valid because intra-EU BAT. The court did not dismiss this argument saying it's inappropriate at this stage for these proceedings. It actually said, well, I will not address this because it's not to English court to assess validity of a treaty between two foreign states, and in any event, I'm going to stay proceedings because there is another issue pending before the General Court of the Court of Justice. So that was the conclusion. Another point where this issue can be smuggled in are in the states which require assessment of immunity before enforcement, and here of course the practice of US courts is quite notable because of the Foreign Sovereign Immunities Act and its arbitration exception to foreign sovereign immunity. It is precisely this branch of case law which offers us the most recent developments in the energy sector, when in August this year the Court of Appeals finally resolved a dilemma among lower courts about whether intra-EU nature of treaties leads to invalidity of EU treaties, which therefore leads to the point that the arbitration exception under FCA is not triggered. It actually concluded it does not, but so that still arbitration exception is triggered. However, it still left possibility to lower courts to still conclude in concrete cases that in those concrete cases still the arbitration agreement was not concluded due to intra-EU nature, and therefore to dismiss motion for enforcement. Now, these are examples of only critical cases where there were still some dilemmas among lower courts and then resolved by higher courts. Of course, in some other jurisdictions, enforcement goes more smoothly. UK is one of those countries. So finally, what does this mean for the Western Balkans? Of course, the obvious difference here that I'm talking about is whether we are talking about intra-EU cases, extra-EU cases. Because we are out of the EU, enforcement still should not suffer due to these developments in the Balkans, but we are internally hoping that we're going to join at one point, which of course I'm not going to present you as something you should expect in the near future, but if it happens, of course we will need to adjust, because from now on investment disputes are internal matters of the EU. The more important, bigger difference that I would like to point out is the difference between ICSID and non-ICSID cases. First, one could tell, but of course there is difference, because in non-ICSID cases you have recognition proceedings, which in ICSID cases you don't have. But as I previously said, this, on a more closer look, this difference is not so obvious, because due to registration or executor proceedings, you can still smuggle in some jurisdictional questions preventing enforcement. But the bigger added value of the ICSID Convention that I would like to pinpoint is that the ICSID Convention still has the clear, unambiguous obligation of member states to recognize and enforce ICSID awards, which is absent in any other procedural frameworks. And at least outside the EU, this can be the prevailing factor, because at least outside the EU, courts are now, at least for now, not they do not face dilemma whether ICSID obligation to enforce is superior or not to the EU law command that you cannot arbitrate these disputes. But again, case in point is Mikula versus Romania, where it was the UK Supreme Court which eventually allowed enforcement to proceed, precisely relying on this point that UK was obliged to recognize and enforce ICSID awards, and this was during the period when UK was already outside the EU, but still had to apply the EU due to temporal factors. The same point was actually made on numerous occasions by US courts, so it's a good point to make. I would do the same if I would be one of the judges. And of course, as in every case, there is also this question about the underlying treaty, but I think that question was more than enough addressed by my co-speakers, so I will leave it at that. So these are some questions about enforcement. I hope don't give you hopes up. It's still possible to enforce these awards, so keep it going.
Thank you so much, Relja, for these important points. And I think, going back to something you mentioned earlier, all of these distinctions in understanding and application come from an understanding by the EU of the nature of EU law, which through its interpretation what we can see is that they are at the same time international law, but also EU law as such that applies within the EU itself. So whenever there's anybody raises the question of a clash, that's the EU's answer. They say, look, we understand you, but this is how our law operates in these decisions.
Yeah, so it is my firm belief, you can disagree with me, but it's my firm belief that EU law is not international law. EU law is national law of the state called into European Union, and the point on which I base that opinion is that the theory of supremacy of EU law over international law, as we have in all our states supremacy of our constitution over international law, and that's that. But the point made by the Court of Justice of the European Union in this case is, which I found personally much more ridiculous than this, is the point about autonomy of EU law, which basically means this. I, Court of Justice, can interpret EU law, can interpret domestic member state law, can interpret international law, can even interpret foreign law, but none of them can actually interpret EU law. I think this goes against any sensible legal reasoning, and that is something that we should fight.
And just as you're raising these cases, a calm story comes to mind. Usually, so you mentioned also that it should be governed by legislation properly and not the court jumping in when they see the opportunity, even in a case that is not EU law, even in a case that's not under the EU in any way. And a different question is that exactly because of this fundamental question of the nature, how the EU sees the nature of its legislation and decisions, and also how the international framework would and does outside of the EU apply these matters. And this is that the interpretations that are being asserted now are phrased by the EU as reaffirmations of long-standing policy. It was always understood that the ECT shouldn't apply intra-EU. It was always this case that you cannot arbitrate these matters. Apparently, for some reason, now we have to restate this, so here you go. So instead of having legislation, the CJEU would confirm it, and then you have these most recent declarations when all EU member states, with the exception of Hungary on the position specifically, will say, yes, this is also how we see it, there should not be intra-EU arbitration, for some retroactively, for some prospectively, for Hungary, for example, prospectively. So just open to the panel, how do you see this interpretation of the nature of this legal framework impacting future practice, starting with you, Relja?
No, I think the most important point for understanding the three critical decisions of the Court of Justice is, first, these were not binding decisions. These were not res judicata decisions. These were decisions in cases for preliminary rulings. So it was advice given to lower courts. Of course, it is binding in terms of judicial pressure, but this was not proper case between two parties with binding res judicata force.
Florian, yes, sir.
And another thing, I don't see issue in retroactivity. You can sue actually this is a point that I would suggest, 2 member states of the European Union can sue each other based on the exclusive competence of the CJEU clause from treaties for declaratory relief to find that their treaty, their BIT, was invalid since days back when they joined the EU. But none of them did that. None of them did that. That would actually be binding.
Yeah. So, Florian, do you have something on this point?
No, maybe just one additional. I absolutely agree with your assessment. Just maybe one critical point which highlights the adversity of EU institutions towards arbitration. If you read these decisions carefully, what they're actually saying, I think in the Achmea, that's in part of the Achmea decision, the reason why this was precluded all along was that arbitral tribunals would be called to hypothetically, not even if they apply EU law, but if they hypothetically have to apply EU law, which is basically every case, because there can be a question of competition law in every case, then international arbitration cannot take place. They have made a distinction between treaty arbitration and commercial arbitration, but intellectually this distinction is non-existent. So that there is no intellectual distinction why why treaty arbitration is in this respect different than contractual arbitration. What I fear is that we will see a gradual clawback even on commercial arbitration, which is, I think, a great fear of mine. Yeah.
Absolutely. Thank you so much, Florian, for those practical points from this perspective. Kabir, you also had some insights?
I don't know where to begin because there's so many things that I want to comment on, but I think I should, because I think this is important. I think there was a very partial account made for human rights, and I think it's important just to clarify that, because there is a whole branch of business in human rights where there is a shared obligation. It's not just the respect, protect, fulfill obligation is a shared obligation between investors and companies. There is now at least 5 treaties internationally that establish this, so I don't think it's accurate to say. But I think more fundamentally, the bulk of what we are seeing states do is preserve their human rights obligation. And I think that is very important because, this is something that Samira alluded to. We're talking about general measures that an investor challenges and the state has to justify. To the extent it can anchor it in human rights and environment, that is a good thing. Currently, there is no framework and we're leaving it to the discretion of the tribunal, and tribunals may or may not accord the weight that we think they should. To the extent states are putting direct obligations on investors, and this is limited, but things like do not pollute the environment, we're doing that in national law. Administrative law gives you the polluter pays principle. To the extent we are saying don't engage in corruption, national law does that. So I don't see what is happening here is a necessary, in my submission, actually not going far enough effort to try and grapple with these issues. And it is completely consistent with the business and human rights framework. I felt it was necessary to put that.
Very, very important. Thank you so much, Kabir. Yelena, do you have some comments?
Well, maybe in terms of the declaration of the on the part of European Union on non-application of the ECT or the sunset clauses, I definitely do not see either the declaration or the inter se agreement as being in compliance with the Vienna Convention, either Article 31 or 41. So that is the point. But on the other side, I mean, the problem with enforcement will still persist. So these are maybe it is important to talk about that from the academical point of view, but the practical points is there.
And exactly the one separate declaration by Hungary is the only one that indicated this point, that said, yes, prospectively, in accordance with international law, if we modify the ECT to the effects that the EU is stating, that you can annul the sunset clause, that this no longer applies for the future, they're the only ones who brought this international law interpretation into this context, surprisingly for many. So before we just open for the audience as well, I just want to raise, again, bringing it home, bringing it back to the states, those states who are represented here. These broader policy positions, especially when a state like Bosnia and Herzegovina is now engaging in policy reforms that are also captured in standards and principles that will be publicly available, and the state will be held accountable to that. Then as Bosnia and Herzegovina and the countries in the region are transitioning into the EU, they are already bound by the New York Convention, the ICSID Convention, awards that have been issued prior to any context of the EU applying to them now, even though they didn't help Mikula in many respects. At this point, they're facing obvious discrepancies in these two legal frameworks, what they expect from them. What can the Western Balkans governments do when they're considering now this balance of compliance with international law or this prospective compliance with the EU regulations that are available? And I also, maybe first to hear from, I know Samira raised her hand, but then also anyone else who's interested, and then Kabir and the panel, we can wrap up with this kind of final question.
I'm sorry for taking the floor again, but this is so interesting for me. So thank you all for giving different perspectives. I just want to comment on a few things. Right to regulate. I remember at least Kabir and Fahira know me commenting so many times that I cannot understand that we as a sovereign state have to put in the international treaty that it is our right to regulate. I think it's obligation, not only right, because otherwise it would be anarchy. But when we started reading certain awards of certain arbitration tribunals, it turns out that it's useful to put in the treaty that actually we have a right to regulate. That's something that we experience. Second, the EU law. I can, like in discussion with what Relja said, I can agree with most of the things that have been said. But this is kind of thing that is not like, you know, very much a problem for us at this point of time, because we have more urgent issues, and honestly, I'm not very much concerned with how the EU is dealing with this, because they are imposing to us what we need to do. So whether we decide or not, I mean, this is something that we are going to do one way or another if we pursue the membership of the EU. And I don't think we have great influence to whatever they do, on the contrary. The third thing that I wanted to point out is that I heard the definition of empathy a few days ago, and I liked it very much. And it says something like, okay, it's the ability of one person to put itself into the shoes of another person to try to understand their perspective. That's what I've been doing as a state representative, to understand the perspective of an investor. As such, I understand why they need ISDS, and I personally have nothing against ISDS whatsoever. The point is that I rarely see people on the investor side understanding the position of state, because the interests of the state and the objectives that we pursue are not only legal, they are economical, they are legal, they are political. Just to give an example, the objective to become EU member state is highly political, and we cannot quantify that. So in doing so, we have to align also in environmental section. And how do we calculate proportionality? I'm just, you know, maybe I'm saying something stupid, but okay, I will say it anyway. So how do we calculate the proportionality of state, you know, adopting an environmental law, which is costly for us, by the way, and at the same time exposing ourselves to being sued by an investor who, on the other side, has expectation that there is a certain regulatory stability, which is understandable for me, and how we kind of make a balance between the two. So the states do wrongful things to investors, and I don't argue that at all. But also there are a lot of situations where states are, well, I will say this bluntly, felt like totally exposed to the will of 3 persons sitting in the arbitration tribunal, deciding on your fate based on something that we concluded 25 years ago without even having a clue what kind of legal consequence that can be, and with no right to appeal, and voila, that's international law. So I'm just, you know, throwing bombs, more bombs to, to this discussion. Thank you.
If I may briefly address a few points, and I don't think that there is a large, I disagree with any of your points, because the details actually are important, yeah? and usually that is very fact and case specific. If you say you don't want to be bound by treaties that have been concluded 20 years ago by people you didn't even know, well, that is always the case in international law, and there is, states are bound by their international obligations even if previous administrations have concluded them, and that is, I would say, a general principle of international law, as the ICJ has said on many occasions, and in relation to environmental changes in the Gabčíkovo-Nočmaroš case, for instance. So that's the first. And the second is why there should be limits to government regulation. Well, I'm absolutely in favor of environmental regulation and stronger regulation. The only limits are those that the rule of law requires in many, I would submit, virtually all states, even in their domestic system. And I don't think that this the shock about having that as an international, at the international level, is really well founded, because this is something that we know, and we have constitutional courts that decide very important matters, and in the same way as we entrust international tribunals to do that. So I think there is, on the one hand, the way we may comment on and even criticize specific decisions, and on the other hand, the system of international justice, and I would strongly argue that we should not tamper with that.
Thank you so much, Florian. We'll give the floor for the final comments, concluding, to Professor Bermann, because a historical and beautiful building like this also limits our stay, but definitely conversations to continue over dinner, and thank you all for your strength and energy towards this end. So please, Professor Bermann.
Okay, thank you. Thank you. There's so much been said here of great interest, and about which, on every piece of which I have views, as some of you may know. And I have to be very selective here, okay? And I don't want the EU to hijack this panel, but it's very tempting for the EU to hijack this panel. But before I go there, I do want to second something that Samira said. This is going to sound a little bit heretical, particularly from somebody who is an international arbitrator, but your reference to 3 mortals. I have asked my students, they've never done it, but I've asked my students to go back and add up the amount in controversy in every case in which my very good friend Gabriel Kaufmann-Kohler has sat as arbitrator. I invite you to do it too. If there aren't enough digits, to account for the incredible weight that this system is giving to mortal beings. And I'm a friend of ISDS, but if there's anything that's going to drive us toward a court, for better or for worse, and I'm sure there's a sentiment that it's for the worse, it's going to be this idea that we are empowering people like myself who do not deserve to have the kind of power that I have to dispose of the GDP of a country. I think we've just taken that for granted, and I really would invite the panel to just stop and think for a minute, however hostile you might be to the idea of a multilateral court. Just exactly how comfortable are you that, again, my very good friend Gabriel Kaufmann-Kohler, I could give you other names, that they have the prerogative as human beings, individual human beings, to make decisions so consequential for the world and for the population of states. So I'm someone who has benefited a great deal from the system that we operate in, whatever hat I'm wearing, whether it's teacher or arbitrator or expert or whatever. But there's something troubling about that. Now, to become even more outrageous, let's turn to the EU. As far as I'm concerned, you understated the problem, if anything. And I want to just quickly go through a couple of things that I think are outrageous that the EU has done in this regard. I think the first thing I want to say is the hypocrisy is of proportions that I can't even accept. Here's the ECJ saying in Achmea that it's contrary to the autonomy of EU law for a tribunal that can't make a preliminary reference to the Court of Justice to make a pronouncement about EU law. And then it goes ahead in Opinion 117 and says that a CETA tribunal can do that without any problem. A CETA tribunal cannot make a preliminary reference to the European Court of Justice. It cannot. It has no more right to do so or ability to do so than a tribunal under an intra-EU bid. But the ECJ has had the temerity to not even admit that it is willing to allow tribunals under its treaties to make these determinations of EU law, but unwilling to allow tribunals under BITs, intra-EU BITs, to do so. So that whole argumentation bothers me. You mentioned that you thought that that Comstroy was the worst of the three. I think you probably know what I'm going to say. I was the chair in PL Holdings, okay? And not only because I got annulled, it's not just that I got annulled, but it is actually the worst one. Because, as you may know, a Greek court, after PL Holdings came down, said we read PL Holdings as allowing us to apply Achmea to commercial arbitration. That's for you, Florian. Okay, so PL Holdings has been interpreted, at least in some quarters, as, again, it's rank hypocrisy if that's the case. Here's Achmea saying we carve out commercial arbitration, unaffected by Achmea, and then turns around and renders PL Holdings that courts are saying Achmea, you said Achmea applies to commercial arbitration. So Florian, what you had to say resonates with me a great deal about the sanctity of commercial arbitration. I really can't go on much, well, I could go on a great deal longer. But I'm really troubled that it doesn't bother the EU at all, that we have Article 27 of the Vienna Convention on the Law of Treaties that says that states cannot invoke their internal law. And this is when the EU says, oh, we're not a state. Yeah. We're not a state. So we can what is the EU doing? It's invoking its internal law to overcome its treaty obligations. I mean, there's so much wrong here. Now, just one thing that's not polemical, I just want to say. The case you referred to, which is in the DC circuit, and is now back in the district court, and that court is now has to decide whether the award in Next Era, or Nine Ren, or Blasket, you know the cases, whether they are enforceable. One of the questions that's at least going to arise is whether, if the New York Convention doesn't apply to ICSID awards, and it doesn't, then why should we be looking at the validity of the bid? I mean, we shouldn't be looking at it. Now, it's off the table, I believe. But if we look at Blasket, which was an UNCITRAL case, so you keep an eye on this, Florian. Blasket is an UNCITRAL case. So that case is now back in the district court. And the district court there is bound by the New York Convention. And the claim Spain will make is that the BIT, or the ECT, is not valid under Article 5.1a of the New York Convention. That's the argument. And question, what is the law that governs the validity of the Energy Charter Treaty? Now, I can promise you that Spain will say it's EU law that governs the validity of the Energy Charter Treaty. I would have thought it was international law, but I invite you all to see what happens to the district court now that this case has come back. Fahira, I'm very sorry to have spoken so at such length, but there do remain 5 minutes.
Yeah, no, we have to wrap up and get out in 5 minutes.
Sorry.
But exactly, such wonderful wrapping up of all these arguments. And as Kabir said, reasonable minds will continue to disagree on each of the things you just mentioned. So I will invite you all to continue these conversations that we have just now picked up. I'm sorry that I also have many, many answers and questions, but let's put a kind of soft point here. I invite you to continue these conversations in the evening in more relaxed settings where you can kind of tease out, we are all going to do it. We can say it's a networking thing, it's an opportunity to continue. So with that, I will wrap up this investment arbitration panel. Thank you to each and every one of you for such diverse perspectives, for the kind of conversation we had. Thank you for the audience, for your input. And obviously there's much to do, much to say in the future. We will gladly welcome you on future conferences to continue this. So bear with us for 2 more minutes. I will invite Armela also. I will join her at the stand to close this conference and then to let you enjoy Sarajevo fully as you desire. But thank you so much for your attention.
Smatram da zaista smo čuli jako korisne i jako vrijedne stvari. Prije svega, ponovo ću se zahvaliti našim partnerima i sponzorima za celokupnu podršku koju su nam dali. Zaista cijenimo i naše goste koji svake godine iznova su tu sa nama, gdje diskutujemo o mnogo novih izazova u arbitraži, odnosno alternativnim mehanizmima za rješavanje sporova. Ono što smo dobili kao sugestiju danas jeste da radimo event koji je na domaćem jeziku sa simultanim prevodom na bosanski, i to je sa simultanim prevodom, izvinjavam se, na engleski jezik. To je bio razlog zašto sam i željela da nekako zaključim današnju konferenciju na našem jeziku. Ja vjerujem da će Fahira ovo isto uraditi samo na engleskom za naše goste i kolege iz inostranstva. Hvala još jednom i zaista se nadam da se vidimo sljedeće godine u istom sastavu.
Messages to our non-Bosnian speaking guests here today. As a general matter, all thanks are due, of course, to the sponsors, for the co-organization, for many support systems we have had. It is our delight that we were able to host every person here today. And we already received feedback and suggestions from the participants, including, and this is new and this is very interesting, so kudos to everyone of the panelists. They're interested in talking about all of this, but in reverse, in the Bosnian language with simultaneous translation to the non-Bosnian speakers, because obviously without such substantive feedback, without such expertise and knowledge we have shared in the audience, but also, of course, on the panels, it will not be possible to generate such future interest after such a long day and a very challenging conference. So thank you all for making it such. We are already excited to see you next year. Count on us to put the date in very soon so you can know, but this time of year, hopefully in the same weather, and hopefully with many of old and new friends and colleagues in attendance. So thank you all. Please enjoy Sarajevo and see you all again very soon and this evening as well. Thank you.